May I be permitted to mention one matter for taking leave for draw up and complete?
When the order was passed.
Order was passed on 17th of February.
Lordship, mentioning for Lordship's leave to lodge my written statement and for short service of the master summons with affidavit.
When the written and when the writ of summons was served? Commercial?
It was served on 30th. Commercial. It was served on 30th October, Lordship. So if taken from that, I am on the last day today. But appeal court had referred the parties to mediation. So if the mediation period is excluded, then today is the 77th day. Be that as it may, Lordship kindly grants me leave for lodging the written statement in the department and for short service of the master summons.
Leave is granted. Leave is granted to file the written statement in course of the day in the department, subject to outcome of the subject to acceptance by this court.
Much obliged.
Have your lordships kindly, my lord. Item number 77 of my lord's non-commercial list. My lord had directed on the last occasion for this matter to appear at 3:45 p.m. today. Now, my lord has appellate side from 3 p.m. My lord, I was humbly praying, my lord, this is that partition suit, my lord, 2012, where substantial argument, and last occasion I filed my notes of argument also. Can we fix it, taken as to be mentioned, my lord, or fixation of a date, my lord? This
April. Before that, it is not possible. What can be done? All the things have been given to this court. This court cannot adjust everything, so what can be done?
3:45 p.m. today itself.
But I find, but this court has to take the appellate side also. This court has to obey the other things also.
Well, next week may it appear as to be mentioned, my lord.
What will happen to be mentioned? I have not date till second week of April. This court is not having any period before second week of April to fix any matter. That is a problem. So that's why I brought the same as a adjourn motion. If you get the time, I will hear the matter.
Let it appear in the list.
It will be in the list.
If not taken up, I'll mention.
It will be in the list.
If I may request one indulgence, my lord, to mention one matter. My lord, in CS number 14 of 2025, I am for the plaintiff, my lord, which is the matter is listed at serial number 59 in today's daily list. My lord, if I may humbly request, my lord, kindly the matter be taken up at an early stage. My lord, the matter is running low for past week, my lord. I am for the plaintiff. The respondents, the matter actually involved an injunction application, and I have reasons to believe that the respondents are trying to.
What you want actually, you tell no.
Lord, kindly fix the matter today or
what?
any day
For what?
for hearing of application. My lord.
All the cases fixed for hearing when you get the matter.
May I have a lordship?
My lord, respondents.
It is not possible for this court to upgrade any matter, sir.
Much obliged, my
lord. My lord, item number 79, my lord, upon service of notice, my lord.
Lord, I appear
I am submitting. No, my lord, what happened, my lord? This is, my lord, matter is relation to, my lord, voting rights of the, my lord, voting rights of the members of the Indian Football Association, my lord. My lord, I am for the defendant, my lord, upon service of notice, my lord, I am mentioning, my lord, I am praying for some upgradation, my lord.
No. Next.
Let the matter be fixed.
Upgradation, nothing.
Lord,
this court is not having
list, my lord.
Not having a single space to upgrade the matter.
Well, from September,
I will take the matter
from September matter is running.
Maybe.
From September.
Maybe.
Well, I am praying, well, let the matter be.
Sir, what you are not understanding, this court is not having any space to upgrade the matter, to fix the matter for hearing. Well, already all the matters in fixed.
Daily list.
Let it the list. If you get the time, if you place the matter, then you come and argue the matter. What can be done? This court is not having the space to give any other dates.
Well, matter was
if you want, I will fix in the second week of before the vacation, in the last week of April.
argument
Before second week of April, I can't. This court cannot upgrade any matter.
Yes, my lord.
Second week of April.
Already my diary is full till second week of April. If I upgrade also, I cannot adjust you in any of the places. From 11:30 till 3:45, all matters have been fixed.
That's why, well,
nothing can be done.
Watching, well.
Yes.
Well, it was in the daily list. Then thereafter.
It is list. If you get an opportunity, you come and argue the matter.
Monthly list.
Yes.
I have my lord extremely grateful, Lord. Kind leave me lord to mention me lord and Millard CSOS number 3 of 2025. My lord, on 20th February 2025, my lord, this matter appeared with lordship pursuant to my department's requisition on some report. Milord, I had made a wrong submission before the lordship on that day. That Milord, we have already filed the Wakalatnama. My advocate on record was not there with me at that point. He told me that he could not have filed because summons was not issued. My lord had waived the summons on that date, and Milord, we have went, but Milord, department is of the view that my lord had already, Milord, it's hard copy. I'm just calling. My lord had recorded that defendant appears suo motu and has filed Wakalatnama upon my submission. But that has to be Milord rectified. That Milord, then Milord, I can file the Wakalatnama because I have not filed that on that day. So my lord, I can Milord, my lord gives the leave.
You file Wakalan, that's why you're allowed
Yes,
to
yes,
receive
yes,
the
yes.
writ of summons.
Because we started appearing before the master only. Milord, I was under the wrong impression. I immediately when he pointed out to me, Milord, I came before the lordship Milord to mention. Milord, that has to be Milord, perhaps Milord has to be correct.
To be mentioned when
Very well.
Yes. Anything?
CSOS 3.
My lord, my lord, in respect of the leave, my lord just gave me in respect of my written statement. My lord may also kindly grant me leave for short service of the master summons and the affidavit in support thereof.
When you receive the writ of summons?
My lord, 38 October. My senior just mentioned.
Why short service? You serve the copy. There is no requirement. If it will come, yes. Yes. Anything? Nothing.
Milord, I have got the Milord. This was the.
Okay. It will take us. Yes. All the matter.
Number 1.
Happy for the report 1, 2, and 7.
Though I discussed all the point, but at the time of considering, I think that the matter is to be taken as a mentability point first. And I have taken the mentability first and find that who has made the submission before the division bench, the old equity suit has been struck off on the register. I have made an observation, a wrong submission was made before the appellate court. It was still pending, so I find that the suit is not maintainable. The suit is dismissed.
Lordship will dismiss the suit. I'm grateful to Lordship.
And the leave has been.
I'm very grateful.
Leave is revoked.
Very
We are grateful to your Lordship, Mullahs. Much obliged.
Milord, I am for the plaintiff, Milord. But why it has appeared as to be mentioned, Milord?
Yes, where is Mr. Chirania? What is his name?
Mr. Milap Chanchoria, Milord.
He's not here today.
He is there, Milord. Online I can see he is there. Milord, he has taken out 2 applications. Milord, one, Milord, stating against me that in 2022 I had followed him.
My lord, I am here.
It has been taken out.
Yes, Mr. What is your name?
Milap Choraria, my lord.
Choraria. Mr. Choraria, I am passing a judicial order restraining you to send any communication direct to this court by name.
Okay.
Every now and then, once today, if the matter is taken up, evening I don't think you are having any time. Then you started writing and sending the direct letter to this court in name by name. If you have
Sorry, my lord, I am apologizing.
If you want to file any application, you file any application in accordance with the law, the court will take into. I have kept all your give what kitna letter aa dijiye.
My lord, I am a innocent person.
You may be innocent person, but innocent person cannot write every day. See, these are the letters you send directly to me. Can I issue the contempt against you?
Apology, my lord. I am tendering apology, but I am suffering. That is the very thing.
And kindly see the address. It is not the court. Justice Krishna Rao.
Where I have to send.
I am taking all this. I am passing a judicial order restraining you to sending any letter by the name of the judge.
Okay, I will not send your by name.
And if you want to file any of the whatever the applications you filed, if you file the application in accordance with law, that this court will take cognizance. Otherwise, this court will not take into consideration of any of the communication made by you.
I don't understood by my lord that how I can get justice because I am suffering very much.
So you are suffering very much. It is not that you may write a letter directed to the judge.
No, I have no intention to.
Record an order. The matter is listed as to be mentioned on the receipt of the speed post letter through one Mr. Milap Choraria, who is the defendant number?
Defendant one.
who is the defendant number 1 in the present case. Full stop. It is fine that every now and then the defendant number 1 is sending a written communication, either way of application or way of a letter, directly addressing to this court
My
by
lord,
name.
I am tendering apology. I am tendering apology, my lord.
Directly to this court by name of the judge.
It is also recorded my tendering
By the
apology.
name of the judge. It is also fine from the record whenever the matter is mentioned either by the defendant number 1 or the counsel for the plaintiff, the matter is been listed either to be mentioned or for orders or any of the heading.
Yes.
But the defendant number 1 time and again has taken the time from this court on the ground that he has preferred an SLP before the court. And now the private defendant number 1 is blaming this court that the court is being the senior citizen, the court is not taking up the matter.
No, I am not saying that. I am not said, my lord. That I am not said.
Court restrained the defendant number 1, Mr. Milap Choraria, to send any written communication or to send any communication either written or through any mode to this court in person, to this court by name of the by name. If full stop, if the defendant number 1 is having any grievances, he can make appropriate application in accordance with law so that this court can take into consideration of the application. Accordingly, the applications filed by the defendant number 1 by sending directly to this court by name of this court, the same had not been accepted. If the petitioner intends that this application is to be taken on record, the petitioner has a liberty to file the said application in accordance.
My lord, my apology should be recorded.
Now,
my apology should
after
be recorded.
the order, the defendant number 1 has prayed for apology for the act which he has committed by sending a direct communication to this court by name. Full stop. The apology is accepted, but the defendant number 1 is warned not to send any communication directly to this court by name.
I will not send any communication directly to court.
Sir,
by
see
name.
this is what is this? Whose letter is this?
That is my mistake, my lord. I am attending.
And you are telling that you are not sending. Now you are telling that by mistake. Kindly see this.
My lord, this
I was not aware that I
my lord
cannot send
Justice
by name.
Mosumi Bhattacharya, my lord Justice
Okay.
Kapoor.
Full stop.
My
Yes.
lord,
What application is
My
pending?
lord, he has taken out an application under order 7/11. That is
GA
year
number?
4 of 2022. Affidavit is
filed the
complete.
affidavit?
Yes.
The defendant number 1 has filed an application being GA4 of
2022.
2020-22.
my lord, my application also 15 January 2025.
Praying for rejection of the plaint.
My application dated 15 January 1922.
Counsel for the plaintiff submit that the pleadings in connection with the said application is completed. Full stop. Let GA4 of 2022 be placed under the heading adjourn motion for hearing on.
This also we recorded, my lord, that 15 of January 25, I also sent application according to your honor's direction.
15 January?
Yes.
Lord, 15 January 2025 application is taken out against me.
Where is that?
My lord, I do not know. He has sent it by post.
What is the number?
There is no number. Yes.
If you directly send to this court, it will not be registered, sir. You have to send to the department.
My lord, department is under embarrassment of the Manju Agarwal. She is impressed. She is intended to
matter on
arrange my killing.
आज क्या तारीख है?
I have
matter on
wrote in written.
March. 6th of March. Under the heading adjourn motion.
What date is fixed, my lord?
6th March.
6th March.
Next. Item number 3.
On 20th February, your lordship was pleased to pass an order because the In the applications, my lord, your lordship was pleased to ask the where is the genealogical table for which your lordship. This is order is I'm placing this.
Yes.
But the plaintiff and my lord, the defendants are my lord, the cousin brothers as well as my lord, the maternal uncle. Sorry, the paternal uncle.
It is a to be mentioned. Why to be mentioned?
Because your lordship's last occasion, my lord, I asked my lord, the
Why it is to be mentioned?
because of the ad interim order has not yet been passed, my lord, or injunction.
No, at the top. So suffering for the plaintiff. In terms of the order dated 20th February 2025, the petitioner has filed the genealogical table. Let the same be kept with the record. Please the matter.
One of the ad interim injunction, my lord, is required to be.
So to be mentioned, ad interim injunction cannot be taken into consideration, sir.
The last occasions also
Let
issue
the
which was
matter appear
appear
on.
under the heading to be mentioned.
Let the
As your
matter
lordship
appear
so
on 5th
desired,
of March under the heading new motion. Next.
May please, your lordship.
My lord, in this matter, my lord, I am appearing on 15, my lord, Election Commission India, my lord.
In this matter, my lord, I am appearing on behalf of the state, my lord.
Take it. The state, first of all, is not a party. As
I am appearing on behalf of respondent number 16.
Yes. So respondent number 16 were supposed to file their written statement in the department.
Yes.
In terms of my lord, last order dated 15th of January 2025.
May I humbly beseech your lordship that
Yes.
Yes, there were, despite our filing the written statement with the department, later on it was discovered that there were a few signatures that technical defects were there. If lordship grants us the liberty, we will rectify that also, and a direction be passed to the department.
Register address of the respondent. Have you rectified the defects?
No, but
Liberty may
defects
be
are in
granted
the
to
written
us.
statement, my lord.
Though I have circulated the copies.
Scrutiny by the department and written.
Copy we have received,
Yes.
my lord.
There are four defects. Are
Yes.
there. So how much time you want?
4 weeks. 4 weeks.
4 weeks. These are small defects.
They can do it by the course of this. By the course of next week, they can do it.
Yes. Another thing, yes.
And my lord, regarding the remainder, my lord, of the order, my lord, may kindly grant my lord me 4 weeks time because there are certain documents, but which are to be produced, my lord, which is taking some time, my lord.
What?
Regarding my lord, the discovery and inspection.
Not completed.
No, my lord, it will take some time.
Last order time.
Kindly grant us, my lord, 4 weeks, my lord, more.
हम लोग 1 वीक एक्सटेंड करवाते हैं, रुको प्लीज.
तुम्ही बोलो. हाँ बोलो ना.
इन लोग का कौन ठिकाना है, ये लोग छुट्टी पे चले गए हैं, नहीं आएंगे.
So 4 weeks, my lord, for completion of discovery and inspection, and a week thereafter, my lord, for filing of affidavit of document, my lord.
Yes. Discovery inspection within a week. Not done.
No, my lord, there's, I'll be very candid before your lordship, my lord. This particular document, my lord, this is still awaited, my lord. We are following it up, my lord.
So suffering for the plaintiff. So suffering for the petitioner. So suffering for the respondent number 15.
16.
16.
I am for 15, my lord.
So suffering for
And
the
I am for the state, my lord.
number 16. What is the state is not a party here. Only there is a direction for that. So
the more they appear, the better it is for me. the more they appear.
So appearing for the state.
It is a state-sponsored corruption, my lord. That will, my lord,
This court
bring
has-
home the case, my lord.
No, my lord, not at all. Report has been submitted, my lord.
The section officer of the office of the London Master has submitted report wherein it is found that the written statement filed by the respondent number 16 having altogether 4 defects. Accordingly, Learned Counsel for the respondent number 16 prays for 2 weeks time to rectify the defects. Accordingly, the defendant number 16 is directed to rectify the defect within 2 weeks from date. Full stop. By an order dated 15 January 2025, this court directed the parties to complete the discovery and inspection of the document. But the Learned Counsel for the plaintiff submit that some of the document is he has not received some of the document which is to be forwarded to the plaintiff for inspection. Accordingly, he prays for 2 weeks time.
My lord, may grant me 4 weeks time, my lord. My lord has seen the nature of the document, my lord, and my lord,
He
the
prays
authority.
for 4 weeks time to complete the discovery and inspection of the document. In view of the submission made by the counsel for the plaintiff to complete the discovery and inspection of the document by the parties is extended for a further period of 4 weeks.
There
from
and also, my lord, there has been no document which has been
yes.
produced till date,
for
my
a
lord.
period
Let
of
us
4
first,
weeks. I am giving you complete
both
4 weeks from date. Fully after completion of the discovery and inspection of the documents, comma, the parties are directed to file their affidavit of admission and denial of the document within 2 weeks thereafter.
Grateful to your lordship.
Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Please the matter. On 9th April 2025 for framing of issues.
Extremely grateful to your lordship.
Framing of issues.
Extremely grateful.
I'm
Great.
grateful, my lord.
Yes.
With your
Much
lordship.
obliged.
This has appeared at my instance, my lord, that restitution matter, my lord, where, my lord, I am only supposed to respond, my lord, in rejoinder, my lord. Any date may be fixed, my lord.
I faced my lord's
So
wrath
this
in
was,
the morning when I mentioned the matter. I'm not going to say anything.
This was, my lord, this was fixed. This was fixed, my lord, for hearing. It could not be taken up on that day, my lord. Thereafter, no time.
Time will take
15-20 minutes, my lord. Any day, my lord.
the new motion. So and so appearing for the plaintiff, so and so appearing for the defendant. Though the matter is when it was fixed.
Last copy fixed.
Last copy fixed, my lord.
Though the matter was fixed on 24th of January 2025, but the argument could not be completed. Let the matter appear. कोई 345 खाली है क्या? नहीं.
345 मैंने कहा appellate से कितने clash हुई है?
3 p.m. 3:45 very risky slot.
Like today, it was for me.
Let it be as to be as it adjourn motion.
Adjourn affidavits were completed here.
All right, I'll take my chance at 3:45 any time.
But 24th March, that is 24th March, not before that. That's why morning I told him.
Yes, that's why I'm not saying
I would wait a safer date when the matters can be heard. My lord, I can wait till first week.
Or may it appear, my lord, in the list, my lord, because my lord will not be.
24th March at 3:45.
Very well, my lord. I shall come. I'm deeply obliged.
Greatly, my lord.
May it please your lordship, my lord.
Yes.
Item numbers, my lord, 6 to 12, my lord, are all
6 to 12.
6 to
My
12.
lord, 11 is different, my lord. 11 I will make submission.
Why?
No, I have not even said anything.
You said 6 to 12.
I said,
Why to be mentioned all this?
yes, my lord, these are all, my lord, suits for recovery of monies lent in advance where I appear on behalf of the plaintiff. So, my lord, we had mentioned the matter because these matters, my lord, were not taken up for some time. Then your lordship was pleased, my lord, to keep this matter under the heading to be mentioned, just to ascertain what is the stage of the suit. And then likewise, my lord, to fix dates. My lord, may I hand up, my lord, for your lordship's convenience? I have prepared a small chart disclosing, my lord, the case status of each matter
Hmm.
to indicate only, Milord, what is the stage of the suit.
Written statement filed.
Yes, Milord.
Injunction pending,
First,
application
written statement
pending.
filed, Milord. GA1 is my injunction application, and GA4, Milord, is my application for
Order 12 Rule 6.
Yes, Order 12 Rule 6, Milord.
What about the suit?
Yes, Milord, written statement has been filed. Since, Milord, we have the application under Order 12 Rule 6, the suit has not independently
For
been
the
proceeded.
defendant in the matter?
Milord,
Your Lordship, in item number 6, I am appearing for the defendant.
Yes. So, with regard to the GA1 and GA4 pleadings completed?
Yes, Milord.
Both.
Yes, Milord.
Pleadings completed.
Milord, any date in April, Milord, I am ready to be present before your Lordship.
My lord, mine is item number 11.
I will come one by one. Item number 6. So-and-so appearing for the plaintiff. So-and-so appearing for the defendant. Counsel for the plaintiff submitted. The defendant has already filed written statement in the suit. Full stop. The plaintiff has filed 2 interlocutory applications, being GA1 of 2021 for interim order and GA4 of 2023 for judgment upon admission. It is submitted that the pleadings have been completed in connection with interlocutory application and prayed for fixing the date for hearing. In view of the submission made by the plaintiff, let CS 72 of 2021 along with GA1 of 2021 and GA4 of 2023 be fixed on, give the date, April 2025 at 2 p.m.
Milord, now with the next matter, Milord, that
yes.
is item number 7. Against Gyan Nidhi Trust, Milord.
Who is appearing for the defendant? Written statement filed.
Yes. Written statement has been filed by an order dated 9.
Others, there are others, all defendants
Yes,
filed.
different against trust. The trustees are representing, Milord. Your Lordship will see the
issue frame, the discovery completed.
I am, Milord, humbly beseeching for direction for discovery and inspection of documents.
As per my written statement has not been filed.
Plaintiff is telling that the
No, written statement has been filed by an order dated 9th of May 2024. And I have disclosed it in the
file it. So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Learned counsel appearing for the defendant submit that it is a change brief and he prays for leave to file wakalatnama on behalf of the defendant. How much time? 1 week. The defendant is granted leave. The learned counsel for the defendant is granted leave to file wakalatnama within a week from date. Full counsel for the plaintiff submit that defendants have already filed written statement and prays for direction for discovery and inspection of the document. In view of the submission made by the counsel for the plaintiff, the parties are directed to complete the discovery and inspection of the document within 3 weeks from date. Full stop. On completion of the discovery and inspection, affidavit of admission and denial of the document be filed within 2 weeks thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Full stop. List the matter on 3 weeks, 2 weeks, 5 weeks, na? List the matter on 10th April 2025 for framing of issues. Next. 8.
Item number 8, Milord.
Milord, I appear for the defendant.
Here, written statement has been filed, Milord. GA1 is the injunction application, which is pending, Milord, after Milord, and all the pleadings have been exchanged.
And written statement discovery inspection?
No, Milord, connected to that is item number 10, which is Milord, a review. We had filed, Milord, an application under Order 12 Rule 6. It fell from your Lordship, Milord, that it is covered under the Bengal Moneylenders Act. But, Milord, the transaction was through check and RTGS. So, Milord, just to clarify that point, the review application, Milord, has been filed.
Item number 8 and item number 10.
Milord, item number 8 and 10. Milord, I would be beseeching if the review can be taken up and heard.
Review application affidavit filed?
Yes.
We have not filed any affidavit in review application because, Milord, this is the question of law, Milord, whether at all, Milord, as I remember, Milord, Lordship has kept, Milord, the even maintainability open in the review application on an oral hearing, Milord. For the purpose, because all pleadings are completed with regard to, my lord, the application, which was decided by your lordships.
8 and 10. So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. Counsel for the plaintiff submit that the plaintiff has filed an application, a review application being RVWO number 24 of 2024 for review of the order dated 24th February 2024, passed in GA3 of 2023 in CS number 142 of 2021.
Lord, I think the order should be, my lord, 24th of April 2024, my lord.
4th of April.
Yes, that's the typographical error.
Full stop. In view of the above, this court is of the view the review application is to be disposed of first. Accordingly, CS 142 of 2021 along with GA1 of 2021 and review number 24 of 2024 be placed before this court. Give the date for hearing of review. 22nd April at 2 p.m.
Lord, for hearing of review application.
For hearing of review application. Then
it is understood that my learned friend will not be using an affidavit. That day should be fixed for hearing.
Yes, so
hearing.
that,
yes, next.
Milord,
9.
Item number 9, Milord.
Yes.
This, Milord, in this matter, the writ of summons, Milord, has returned. Then may I hand up before your lordship, Milord, a service report. We only know the address, Milord, which is there in the cost title.
Could not be served, the defendant was not found at the address.
So, Milord, I am most humbly beseeching if your lordship, Milord, grants us liberty under Order 5, Rule 20 to make paper publication in two newspapers, Milord, English and Hindi, because the lady, Milord, is a Hindi-speaking woman.
No, but whether you pasted?
No, Milord, this is the procedure which we have followed, Milord.
Item number 9.
Two kinds of service have been affected, both have returned.
For the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff has handed over the service report dated 5th September 2022, wherein it is found that the writ of summons could not be served upon the defendant either through the bailiff or through the postal service. Accord. Full stop. Counsel for the plaintiff prays for substitute service by way of publication. Consider the submission made by the counsel for the plaintiff, peruse the service report. The plaintiff is granted leave to publish the notice of the suit in the English daily newspaper, the Times of India and Hindi newspaper.
The Times of India would be, Milord.
What?
I'm making the same request
What?
like everyone else. Milord, may it be, Milord, Hindustan Times instead of Times.
Hindustan Times and?
And Milord, Hindi newspaper? What? Sunmark. Sunmark is a popular Hindi newspaper.
Sunmark. Hindi newspaper, Sunmark. Bangla?
No, she is Hindi speaking.
Hindi newspaper, Sunmark. Within 2 weeks from date.
2 weeks.
Police. Next 10, 11.
But over here, Milord, item number 10, it has already been
11.
Yes, 10, Milord, already been fixed on May 7, 2024. Item number 10, Milord, it is a matter where issues have been framed, and your lordship was pleased, Milord, to fix the matter.
10 already passed. 8 and 10 is 6.
Oh, I'm sorry, Milord.
11.
11, yes. 11, Milord.
Witness action.
Yes, it has already been fixed.
My lord, I appear on behalf of 11, my lord. My lord, I have taken a loan of 4.75 crores in 2017. In 2018, I repay the full amount, my lord. It's given in their plain.
Have you filed the return statement?
Yes, my lord. I filed.
You have disclosed that.
Yes, my lord.
Then you approve. You have to prove that.
And my lord, they have taken 40 lakhs interest also. After 2 years, after the full payment, after 2 years now, they have given the letter that now return that interest.
So, you filed the return statement.
My lord.
Issue has been framed.
My lord.
Issue is framed. Now witness action. You prove it. They will go out of the court if you prove that. So suffering for the plaintiff, so suffering for the defendant. It is submitted that issue has been framed.
And my lord has held that he's a money lender.
Huh?
My lord has held he is a money lender.
There is a review to that effect. Milord, issues have been framed. Your lordship has been pleased to fix the matter for witness action on 7th.
That the matter issue is framed and the matter is fixed for witness action. In view of the submission made by the counsel for the parties, let the matter give the date for witness action.
Milord, it's already fixed on 7th May.
7th May 24.
Yeah, I'm so sorry.
24th April at 2 p.m. for witness action of the plaintiff. Yes, next 12.
Milord,
Grateful, my
in this matter, Milord, our application for judgment upon admission is pending upon completion of pleadings.
My lord, I appear for the defendant.
Milord, I beseech any date and time.
My lord, my instruction, my lord, is that the defendant, my lord, has expired. And I have not been contacted by anybody, and I do not have any document with regard to his
Yes.
No, Milord, if that is the situation, Milord, we have to proceed unless we are formally informed.
Take steps.
Milord, Lordship will fix the matter, and in the
Why
meantime,
fix matter?
Milord, my learned friend cannot
inform
provide me with any document.
But I do not have any document with regard to the case, my lord, but I have been informed, my lord, but the defendant has been.
We don't have any information.
Sense suffering for the plaintiff, sense suffering for the defendant, counsel for the defendant submit that he has received he has got an information. The sole defendant is passed away, but he do not have any document to inform the same to the plaintiff. In view of the above, the defendant is the counsel for the defendant is directed if any information is received with regard to the death of the defendant, the learned counsel appearing for the defendant shall inform the same to the plaintiff within 2 weeks from date.
Lordship will keep this matter written after 2 weeks. Milord.
On 19th March 2025.
Milord, may it be 20th instead of 19th.
20 March. Next.
I'm deeply applied.
Milord, appearing at my instance, one prayer is usual, one prayer is Milord, a little bit unusual to me also. My lord, on 6th of February, my lord had allowed my amendment, directing the department to carry out the amendment. My lord, department wants some more time. That is, my lord, no difficulty. Now, my lord, if my lord, at four places, kindly takes my lord, GA2. If my lord, I don't know whether the GA2 has come.
Yes.
GA2 টা
হ্যাঁ ওই GA2 টা যেটা allow হলো
yes
মানে at 4 places Milad the figure has Milad been calculated wrongly. Milad the 20 lakhs valuation of the locker Milad could not be Milad by missed while calculating Milad the total value of the assets. Now Milad it went down as 125,58,000. It will be 145,38,000.
Where it is?
Where 62 kindly comes to be 62 part of the amended PLA. 8A, paragraph 8A. So Milad that will be 145,38,000. Now Milad kindly comes to page.
No. 62 paragraph 8A was amended.
Yes.
1 crore 25 lakhs.
It should have been Milad 145,38.
148?
145,38.
1 lakh 48.
1 crore.
1 crore
45 lakhs 38,000.
38.
Same Milad at page 70. Kindly takes page 71. The last. 72. Milad 145,38. 145,38. 38.
Then
and Milad at page 70. Milad, it should have been not known, has to be underlined because it's now known. The amount is known. Those are the three.
Page
70. Serial number 3. Other movable property not comprised. So Milad, not known has to be struck off. Those are the Milad 3. Now, Milad, department is of the view that Milad, a leave may be taken from your lordship so that it can be done because citation has not been issued. Stuck because of this amendment.
And where is the first correction?
It's here 62 8A, part of Milad amended PLA, proposed amendment.
Yes,
these are the I can carry out.
I cannot object to this because this should have been there.
That I'm told Milad was calculating in leisure.
First time my learned friend admits that citation has not been issued. So
I'm told Milad department also. Milad kindly these are the one.
By which order is the amendment?
Yes, 6th of February.
Let him again check any further corrections.
I am passing rider, no further amendment.
Or keep blanks as to he can add it.
No, my lord, I am told, my lord, while calculating, he was at leisure.
You are of 1-2 lakhs extra so that you can.
My lord, let them give it to me.
So appearing for the plaintiff. No, petitioner. So appearing for the cavatrix. By an order dated 6th of February 2025, this court has disposed of GA2 of 2025 by allowing the amendment as prayed for by the plaintiff in prayer A to D. At the time of carrying out the amendment by the department, the department has pointed out that the total calculation made in paragraph 8 capital A, 8 capital A, that is page 62, comma
70 paragraph 4A,
comma page 72,
70.
Just a minute. Page 72.
No, my lord, first 70 paragraph 4A. My lord, this amount again, my lord, written 125.58.
70.
70. 4A, yes.
And comma क्या बोला?
ওটা পরে বলছি একটা লাইন শেষ হোক
62 comma comma page 70 paragraph 4 capital A
71 কি
comma page 70
কেন
comma
তো টোটালটা হবে নাকি আর কিছু বল
comma page 72 page 72 the net total
140 কেন মানে
in the net total is to be read as 1,45,38,000 instead of 1,25,58,000. Counsel for the plaintiff further submits that in page 70 annexer A clause 3 it is recorded as not known, but the not known is to be deleted. Consider the submission made by the counsel for the petitioner, comma
not known
the petitioner is directed
page 71 also, I'm so sorry, page 71 also the last calculated figure 125.70 will become 145.50,000.
Page 70
71 right to 145.50
and page 71
1 crore 45 lakhs 50,000
1 crore
হ্যাঁ 12,000 মাইনাস ঠিক আছে
1 crore 41,48,38,000.
No, in 71 it will be 145.50. Then from next page 12,000 will be minus. Then it comes to 145.30. 145.50.
145.50.
The last figure of page 71. 125.70 will be struck off. 145.50.
50,000. 1 crore 45 lakh 50,000.
Yes.
And 12 lakh further.
12 lakh is deducted. That's all right. That comes to 145.38 at page 72.
At page 71 in clause 3. At page 71, the total amount has to be read as 1,45,50,000 instead of 1,25,70,000. Consider the submission made by the counsel for the petitioner. Petitioner is given liberty to correct the figure of the amount in paragraph 8 paragraph 8A page 62 as 1,45,38,000 instead of 1,25,58, page 71 page 70 in page 70 in clause annexer A clause 3 not known is to be deleted, page 71 the total amount is to be read as 1,45,50,000 instead of 1,25,70,000. And in page 72 the total amount is to be read as 1,45,38,000 instead of 1,25,58,000.
And not known.
That is all. This order
yes, part of the 6th
This
February.
order may be incorporated with the order dated 6th February 2025.
The other part remains unchanged.
That is on.
My lord, extend the period for department for 2 weeks, my lord. For further.
The department is directed to carry out the amendment within a period of 2 weeks from date.
Oblige. So oblige, my lord.
Next.
In I am for the petitioner, my lord, there is typographical error in the order, my lord. The date of the will has been printed wrongly.
Yes.
Wrong. There is
Which
a
page? Which
my
page?
lord, first page, third line, my lord. It will be 3rd April instead of 4th April. And in the second page, my lord, it will be the third paragraph, my lord, written 4th April, it will be 3rd April.
Two places. Two places.
Places, my lord.
So and so applying for the petitioner. By an order dated 29 January 2025, this court disposed of PLA number 420 of 2021 along with GA3 of 2023. Counsel for the petitioner submit that in the order dated 29 January 2025 in page 1 paragraph 2 line number 2 the date of the will.
My lord.
The date of the will is wrongly recorded as 4th April 2012. In page number 1 paragraph 2 line number 2 and page number 2
paragraph 4 last
paragraph 4 third line the date of the will is wrongly recorded as 4th April 2012 instead of 3rd April 2012. Consider the submission made by the counsel for the plaintiff petitioner. In the order dated 29 January 2025, in first page, paragraph 2, line number 2, and the second page, paragraph 4, line number 3, the date of will shall be read as 3rd April 2012 instead of 4th April 2012. This order may be incorporated with the order dated 29 January 2020. Yes, next.
I'm appearing on behalf of the plaintiff in this matter, my lord.
Lord, I appear for the defendant in this matter. My lord, today, my lord, the matter is appearing at my instance, my lord, for seeking my lord's leave, my lord, to file this additional written statement. Additional written statement to the amended plaint which was served upon me, my lord.
When it was served?
My lord, it was served on 18th of December 2024. And my lord, 3 weeks was given.
Yes.
No, I'm not objecting to this, my lord.
Your lordship, I'm praying for a week's time, my lord.
What?
For a week's time to file, my lord, because there are some steps which I am told, my lord, stamp punched and all, which will take some
But
time.
it is not ready.
It's a firm, but the order will get uploaded and, my lord, thereafter some steps.
May I make only one humble submission, my lord? Can there also be, my lord, directions for discovery and inspection along with acceptance of written statements so that, my lord, we move a step ahead?
Supreme for the plaintiff, Supreme for the defendant. And the matter is listed as to be mentioned on the prayer made by the counsel for the defendant. Counsel for the defendant submitted the additional written statement to the amended plaint. Amended plaint is ready. Accordingly, the defendant is directed to serve the copy of the additional written statement to the learned counsel for the plaintiff in course of the day. The plaintiff is directed to file the additional written statement in the department within a week from date. Subject to scrutiny by the department. As the pleadings have been completed, accordingly the parties are directed to complete the discovery and inspection of the document within 3 weeks from date. Affidavit of admission and denial of the document will be filed within 2 weeks thereafter. In the meantime, the parties are also directed to exchange their suggested issues. Please the matter on 16th April 2025 for framing of issues.
No, 16th April, my learned friend will be in difficulty. 16th April, he is in difficulty. Maybe 4 to 5 days after that.
After? Okay, for 24th. 24th April for framing of issues. Yes, next.
It has come at my instance, my lord.
Yes.
The extension of time to comply the written amendment, my lord, my lord was kind enough to dispose of the GA, directing certain orders recording of death of the executor in the PLA proceedings, as well as to carry out the amendment. My lord, the amendment could not be carried out at a stipulated time given in the order, my lord, dated 16 January 2025. Now, apart from that, there was also suggested amendment by the department that is to be also already the formalities has been complied with, but in view of the time which has been left.
What do you want?
I am, first of all, only kindly extend the time to carry out the amendment. And I am seeking second prayer.
Where is the master summon?
My lord, it has been already disposed of earlier. By
Day1.
Day1. Yes, my lord. By your
What was the time?
lordship's order
What was the
dated
time?
16th of 2 weeks. 2 weeks.
A to E. Leave is granted to the re-verify.
Certain other prayers were allowed for
No, where in the master summon, how much time you have prayed for?
a fortnight. My lord. That
Where is that?
my lord, that is prayer prayer E, my lord. Prayer E.
Leave is granted to re-verify and reaffirm department direct carry out the amendment within fortnight from the date. Yes.
Yes, my lord. It has not been complied with.
So only this.
Yes, my lord. And my lord, I am seeking your lordships to file this this suggested amendment, which has been pointed out by the department, my lord, that is being annexed as C to this this GO1, my lord.
Suggested amendment?
Yes, my lord. Thing is this, there are certain it is according to department, it is not on order, which I have sought for before your lordship.
No,
subsequently,
what the amendment has sought for, that has been granted. So you wanted further amendment?
No, not further amendment. Only somewhere the legal heirs, name of the legal heirs was there in the GA1. The manner of writing was not in the order as suggested by the department. Now they have pointed out with scrutiny that this is the following manner by which it is to be corrected, which just now I have handed over before your lordship. That is only in that. With that, I have to file it before the department. The manner, my lord, is in my application. The name of the executor name was there in the body of the petition, but in the cause title, the one of the sons who has been empowered by the other legal heirs to affirm this affidavit, his name is in the top. Lords, you will find in the GA annexure C.
Yes, I am there.
Yes, and in the I have just now handed over the copy. That is the humble petition of sovereign. It should be on a humble petition of original cause title should be remain unchanged according to department. So that should be deleted with red ink. That just now I have handed over, and the legal heirs name will be in the after that. That is above name deceased, represent Sovarani goes, the legal heirs and such.
So then you have to file a supplementary. How this will be allowed by the department to you? Because this is allowed by this court. The
earlier one.
Yes, this one allowed by this court.
Yes.
So unless and until you will file a supplementary affidavit stating that there was a mistake, this is to be carried out, then only how the department can do. Because here you ask for some other amendment.
No, not some. In the modality should be
correct.
Modality. Otherwise, I am not changing any kind of name or other thing. And some portion, the deletion has to be made in the grant of probate instead of it's to
yes,
be letters of administration.
It will go as a humble petition of Sovarani so and so so and so.
Yes, the modality is according to them. The modality is not the correct, which I have filed before your lordship.
What is done? And the humble petition of the executor in the will.
Yes.
Testament so and so so and so. You want that is to be deleted.
Yes.
So
and
how the court can rectify here? So you have to come with an application for ratification of this, sir. You have to file a supplementary affidavit by disclosing that, so that this court can say instead of this proposed amendment is to be taken into consideration.
Then my lord will kindly adjourn for a week. I will come back
the
with
prayer made by the counsel for the petition. The case is adjourned.
With liberty to file a supplementary
after a week. In the meantime, the petitioner is liberty to take appropriate steps.
Yes. May I
Next.
file the supplementary affidavit?
Appropriate step I take. The court cannot dictate.
No, sir.
Yes, next.
I take but the proposal. Sorry.
I am the plaintiff in this suit, my lord. Last occasion when lordship, my lord, was considering two applications filed by two of the defendants, GA3 and GA4, for recalling of an order passed by your lordship. My lord kindly takes the order of 27th November 2024. My lord, third page of that order. After, my lord, considering the report of the deputy registrar, my lord, lordship held, lordship rejected the applications, dismissed the applications, both GA3 and GA4, and the suit, my lord, which is a summary suit under order 37, was directed to be listed on 11th of December. Matter, my lord, appeared under the heading suit, but, my lord, business of the court did not permit it to be taken up. My lord, now it's, my lord, ex parte, undefended, my lord, and it's a summary suit. Even without, my lord, evidence, I can, my lord, I will persuade your lordship, considering the provisions of order 37, rule 2 and rule 3, I am entitled to a decree. So I was only praying this, my lord. I had mentioned, citing, my lord, the urgency, my lord, any day, my lord, if lordship gives me 15 minutes.
That is the difficulty. Come in the month of April, I will grant. Before that,
Well, I'll take a chance, my lord, any day, 3:45.
There is nothing. Last it was the 24th of March that Mr. Singh has taken that. That's what morning I told. There is no not to pray before the upgradation.
My lord, difficulty, what we, my lord, practical difficulty, my lord. Undefended suit, my lord, it goes down in the list, and lordship's list is otherwise. We understand the huge burden which lordship has here in this court. So,
I am accommodating all, but what can be done? Every
my lord,
matter
whichever
cannot be
day I get, my lord, I'll take that, my lord. I have no choice here.
Let it be in the list.
But it's not.
Let
It was there from, my lord, December. Lordship had indicated, but it was not getting. But I will not take more than 15 minutes. My lord.
Time. How I can fix?
My lord, April.
So appearing for the plaintiff. You are appearing?
Defendant number 1.
Now it's, my lord, after this, my lord, recalling dismissed, lordship even cannot take note of his appearance.
Appearing for the plaintiff. Appearing for the defendant. Counsel for the plaintiff. Submit that as this court has fixed the this court has.
It's ex parte also.
Counsel for the plaintiff submit that the defendant has not filed written statement, and accordingly the case is
nor entered appearance.
Defendant has neither and no, they have entered appearance. Neither defendant filed application for extension of time to file written or written.
My lord kindly considers the third page of the order which I was placing.
Duly served upon the defendant.
Submitted a report certifying that the defendants have not entered appearance either in person or through advocate till 15th of.
Counsel for the plaintiff submitted by order dated 27th of November 2024. This court has placed the matter in the list of undefended suit. Accordingly, he prays for fixing the matter for hearing of the case for passing summary judgment. In view of the submission made by the counsel for the plaintiff, let the matter appear on 23rd April at 3 p.m.
No choice.
Next.
Grateful.
In this matter, my lord, I am appearing some of the beneficiary of the trust, my lord. My lord, the last occasion, my lord, 8th January, we appear and prayed before your lordship to be added party hearing. Lordship orally directed to go before the special officer and approach. But my lord, we approach on 18th February.
May I,
Learned, my lord, special officer turned down our prayer, my lord, and told us that bring the appropriate order from the honorable court. My lord, this is our situation, my lord. Having no other alternative, my lord, we sent our, my lord, grievance and our objection, my lord, through mail, my lord. My lord, the copy with me, my lord. And my lord, also kindly see the, my lord, the minutes of the copy, my lord, wherein our names have been reflected, my lord. Kindly see.
Yes.
Matter of hearing, at our instance, but we had mentioned the matter. The learned special officer, Lordship had directed for a report to be filed. His Lordship had sealed it and sent it to us for filing. While it's being opened, my lord, I've seen a video clip and I'm also, my lord, instructed as to what has happened. My lord, we had organized an auditorium because we had made a newspaper publication as your lordship, my lord, pleasure was. So, my lord, all the, or rather most of the not investors, beneficiaries, my lord, came. Now, there was a complete mayhem.
Yes.
They kept, my lord, they say that we want money immediately. We are beneficiaries, we want money immediately. Lord, breach of peace.
Yes.
Lordship had to be escorted out by police authorities. So 19 March এগুলো আসবে এই রিপোর্ট
Yes.
Lord, may I just indicate your lordship's order of 12th of September 2024 indicates, my lord, 6 things for the learned special officer to do. My lord, as regards audit and my lord, list of properties which should be sold. My lord, I haven't seen this report, my lord, because it was in a sealed cover. But it may have, my lord, particulars. If it doesn't have, my lord, by 12th of March, his lordship was to, 19th March, his lordship was to file a report. That, my lord, would come. May I, my lord, suggest this? My lord, whatever your lordship, my lord, feels is expedient for the purpose of ensuring transparency, my lord, the trustees are open. If it's an audit, it's an audit. If anything else, my lord, we are open. Number 2, your lordship will also, my lord, be pleased to adopt any means that your lordship feels is proper for the purpose of, my lord, sale of, my lord, the assets of the trust. Because we don't have anything to do with it. We want to divest it. We'll bring the trust to an end. The beneficiaries, my lord, let them get whatever they are to get. It's only that it's not possible to do it without intervention of court, because they will not let anything be done properly. And if there is any objection which they have, let them come before your lordship with an application. Because holding a meeting will not help anybody, because they are snatching away the mic, screaming, shouting, attacking. So there's no point. You know, they seem to be delusional. They think that they'll become millionaires tomorrow.
You are appearing to whom?
My lord, some of
How many persons?
My lord, now I am appearing for 6%.
What about the others? 6%, what is the name?
My lord, Manik Ghosh, my lord.
Hmm.
Manik Ghosh, Mohammad Rabiul Alam,
Hmm.
Gobindo Debnath,
Hmm.
Samol Bormon, Shantanu Bhaumik, Siben Biswas, and Firoz Khan.
Okay. Okay, let the report come on 19.
Yes.
19, let the report come.
Yes.
This interim I am keeping on record. Let the report come. If the report comes, because I don't think the special officer will be able to, as per
No,
this
it is not possible
not
after what has
is the
happened.
act you are conducting.
Rick, one
So
would have
then,
thought.
Then I will pass an order. The publication be made of this in the newspaper. If
Yes.
any interested will come and make their
Applications.
grievance for this.
In fact, your lordship may be pleased to do that today itself. It will expedite the process. And I'll also, my lord, pray for an order that they should not, my lord, the depositors, because they have the liberty to come before your lordship, they should not, my lord, go and, my lord, enter into the trustees' offices, the trustee offices.
So that's why I wanted to see the report of the special officer, what report he has prepared.
Very well.
Before
Because what is the problem which we are now facing is, now that after the advertisement, they are coming in hordes to our offices, entering, shouting, screaming.
That's why I will pass an order. This was done, but it is not feasible for the special officer to act in accordance. So now this court is taking and directing the petitioner to publish the notice of this case. Who are the interested person come before this court and lodge their claim before this court, and this court will decide them.
Exactly. And Millard, these steps for Millard sale may be done either through the learned special officer or through Millard chartered accountants.
Let the claim come. Let the claims come. What are the claims they are making?
Yes,
If they are telling that yes, we are satisfied if the property is sold and their whatever the shares is to be distributed, there is no harm.
Yes. Millard, the originating summons suit, the stand of the trustees is that we want to sell and get out of this mess. They also want a sale.
That's why let they come, because if it is so, it is so easy. That's why I passed the special officer, but I did not find this is so easy.
No. The problem is, Millard, the mayhem being created, which is why we came to your lordship. Otherwise, you would have sold and matter would have been over. So, Millard, what can they possibly say? I ask myself the question. They can say, they'll come and say, sell and give me my money. They'll also say 5 things about the trustees. Whatever they say, whatever your lordship feels is proper to see whether there's transparency for the back period and now, Millard, trustees are willing. Only one protection, Millard, I shall pray for. I'll file an application if required, that they should not enter my office, they should not intimidate me and make, Millard, defamatory statements about me outside.
So I am giving the copy of the interim report to you, and you take appropriate steps.
File an application.
My lord, kindly allow me to file the appropriate application.
What is I am failed to appreciate every advocate grant leave. You have a liberty. If you are having interest of the property, come with an application. Court will allow. This is the trust is coming here. So if you have any interest, only you have to show your interest. The court will allow nothing.
I'll tell your lordship the main problem. Everybody knows that the trust has valuable assets. But people, it's word of mouth. Nobody bothers to see the balance sheet. They think I've got controlling this block of shareholding. Somebody will say 50,000 crores. Somebody will say 100,000 crores. So they believe that they are going to be Bill Gates
person is
tomorrow.
having claim, let them come. They will get it. All these things they wanted.
Let them
yes,
take
now
their
this
money.
This has been left. Let this file if they are having any further asset, details of the further asset.
Anything they want to file.
Bring that. So and so appearing for the plaintiff, and so and so appearing for the intervener. Full stop. The London special officer has filed the interim report. Let us full stop. Interim report. Full stop. The department is directed to serve the copy of the interim report to the learned counsel appearing for the plaintiff. Full stop. It is fine from the record. The matter is already fixed on 19th March for filing a report by the special officer. Let the matter appear on 19th March. Come on 19th March.
Yeah, for the petition. My lord, on this matter, my lord, already probate has been granted. My lord, there has been a little mistake, my lord. My lord, the testator, while making the will, in his will, he has mentioned the name of the beneficiary as Talukdar, and the name of the spelling of Talukdar in the will is AR, but in all of his documents, it is ER. So we have made the application on basis of the documents.
What application?
On the probate application.
Where is the application? Application is not here.
No, my lord, the entire application which was made earlier, the probate
PLA?
application, PLA application. In that application, the name of the petitioner is appearing as Hiranmay Talukdar, Talukder, because the name of the spelling is appearing in all of his documents, in Aadhaar card, voter card, and other documents. But my lord, the testator, while drafting the will, he has mentioned the name of the son as Talukdar, where the spelling is appearing as AR.
Where is that?
My lord, kindly come to the will.
Talukdar, Talukdar.
In the will, my lord. But in all of his documents, he represents himself as ER Talukdar. The name of the spelling is ER. So that is the difficulty that the will is not being granted. My lord, kindly grant me leave to write that alias Talukdar, my lord. Only I am praying only for this leave.
So you have to come with an application.
No, it is already done, my lord. The probate application is completed. Everything is completed. My lord can grant me leave, my lord. Discretion. I'm only praying for this leave.
Sir, order is passed. After the order is passed, whether this court can correct now, that to name.
No, only with regard to surname, I can file an affidavit to that both are same and identical person.
That's what I'm telling. Come with an affidavit with a supplementary, the court will do that.
Okay, grateful, my lord.
As per the prayer made by the counsel for the petition, the case is adjourned. Let the matter appear on 11th.
Grateful.
Next. एक साथ क्यों इतना आ गया?
But
I have to file it by
Let
today.
me please, your lordship, my lord.
Yes.
Yes. My lord, pursuant to your lordship's order, my lord, special officer was appointed. My lord, this is the City Mart matter where your lordship has granted us some protection, and special officer, my lord, had gone, and it is, my lord, the special officer will now be filing the report. So we have received, my lord, the notice which was
Your Lordship, I've prepared all the documents that has to be complied. Kindly grants me today's time till recess. I'll file the entire report.
Time.
Your Lordship,
Time.
till recess.
Till recess.
Till recess, I'll be done. And in the course of the day, Your Lordship.
Hurry, come.
No, Your Lordship, it's ready. Only thing it has to be compiled. And Your Lordship, I would like to mention a few things. Like the whole process was completed in a period of 5 days. And each and every day, both the parties would agree that it started from 11:30 in the morning and it continued till 7:38 or even 9, and I reached home every day around 12, and it was entire process as per order dated 2nd January
What
has
you
been
want?
Your Lordship, I just wanted to intimate this to the court.
Okay, I will see to that. I will see to that. As per the prayer made by the special officer, the case is adjourned. Let the matter appear today. Come, आज कितना तारीख है? 27 है, 26 है. Let the matter appear on the non-commercial, है ना?
Yes, Your Lordship.
On 5th of March, as to be mentioned.
the remuneration part. No, my lord, let there be, my lord, an additional remuneration. Let
Then
there
on
be-
that day come. Let's see. Fine.
Deep-
कौन है? कोई है ही नहीं.
My lordship, this is my PLA application. My lordship, I seek to withdraw this. My lordship, there's some defects in the application. My lordship, I seek to withdraw with liberty to file afresh. My lordship.
So and so suffering for the petitioner. The petitioner has filed the present application for grant of probate. Fully counsel for the petition submitted. There are some defect which cannot be cured by way of amendment, and as such, the petitioner intend to withdraw the present application with the liberty to file afresh. In view of the submission made by the counsel for the petitioner, the PLA number 223 of 2024 is dismissed as withdrawn. Liberty to file afresh. Liberty to file afresh. Full stop. The original will and the other document filed with this application be returned to the plaintiff and to the petitioner, subject to furnishing this copy of the said documents in the department. Full stop. The department is also directed to refund the court fee to the petitioner with the liberty to use the said court fee if the petitioner intend to file afresh.
Grateful, my lordship.
Next.
Thank you.
सारी गाड़ी मैटर नहीं है. Yes.
Lordship, 22, I appear for the plaintiff, Lordship.
Hmm.
Lordship, the dispute in this matter is in respect of a temporary and friendly assistance, Your Lordship, financial assistance extended by the plaintiff to the defendants. I'm seeking, Your Lordship, clause 12 leave and order leave under order to rule 2.
Why order to rule 2?
Lordship, because, Your Lordship, that I have stated in paragraph 16, 17 and 18 of my plaint at page 10 of the plaint, Your Lordship. Lordship, the payment which the plaintiff had extended to the defendants alone, that money, Your Lordship, could not be used by the plaintiff for a long time, Your Lordship, and the plaintiff has lost its opportunity to use it in other business opportunities.
When you paid the amount?
Lordship, this amount was paid on 29th of September 2022.
Yes.
Lordship.
Why
There's
order, why clause 12?
Lordship, there is part payment, Your Lordship. Clause 12, Your Lordship. That, Your Lordship, is at page, I have pleaded it at paragraph 21. It starts at page 20. Your Lordship, the defendants, Your Lordship, they approached the plaintiff within jurisdiction, and part payment has, Your Lordship, it has been made within and outside jurisdiction. It has also been stated in a table, Your Lordship, which is at paragraph 11. Page 7, paragraph 11.
So appearing for the plaintiff. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 46,06,587, along with interest at the rate of 18% per annum. Full stop. The plaintiff has prayed for leave under clause 12 of the letters patent on the ground that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. The plaintiff has also prayed for leave under order 2 rule 2 of the Code of Civil Procedure on the ground that the plaintiff has not assessed the total financial loss and there may be further damage the plaintiff may claim in future. According the plaintiff prays for leave under order 2 rule 2 of the CPC. Consider the submission made by the counsel for the plaintiff, peruse the materials on record and the plaint. This court finds that the part cause of action arose within the jurisdiction of this court and part cause of action outside the jurisdiction of the court. Accordingly, leave under clause 12 of the letters patent is granted. This court also finds that the sufficient pleading has been made in with regard to leave under clause 12 order 2 rule 2 of the CPC. Accordingly, leave under order 2 rule 2 is granted. Plaint is admitted subject to scrutiny by the department.
Grateful, Lordship. Deeply.
Item number 23, my lord. Plaint, my lord. I am for the plaintiff, but only a leave under clause 12 has been sought for, my lord. My lord, as an abundant caution, under precaution, my lord, because all the defendants are within. Only up, but only one part of cause of action, as it appeared to me, my lord, that the check for the principal amount was given from outside, which was dishonored, my lord. That's why, as an abundant caution, the leave under clause 12 has been sought for, my lord. Lordship will find that pleading at, but kindly see, my lord. When the amount was paid? But the amount was partly paid and the rest is all due, and the check securing the principal amount that was given from the jurisdiction outside the jurisdiction. That's why, only for that reason. Otherwise, my lord, all the defendants, see the array, my lord, the defendants are all within. So appearing for the plaintiff. Plaintiff has prayed for a decree for a sum of rupees 1,00,29,729 along with interest at the rate of 18% per annum. Counsel for the plaintiff prays for leave under clause 12 of the letters patent. Had the learned counsel for the plaintiff peruse the materials on record and the pleadings, leave under clause 12 of the letters patent is granted. Plaintiff is admitted subject to scrutiny. Next. Deeply obliged.
Lordship, for the plaintiff, we would like to file a supplementary affidavit with once. This is the transcription of the entire videography, which Mr. Mitra was also saying yesterday that the transcription should be there. So may I file the supplementary? And Mr. Banerjee is requesting if the matter, since they can also have a look and we can take up this matter tomorrow or anytime.
The matter be taken up, my lord. I don't. Only the judgments had to be distinguished.
No, we would be relying on this transcription.
A transcript of the puro video.
So what?
We are over.
It's
okay.
So it's there.
We don't have any problem.
Whatever is there in the transcript is there.
Then admit
Mr. Banerjee is requesting one more,
No,
because he's on legs. He's on legs. He's got some difficulty. Mr. Banerjee would like to place this.
My lord, even if the with humility, and I'm not standing in the way, but my lord, the transcript was here. They were not ready to rely on the video recording. Now they are going to rely on this video recording.
No, we have craved leave on for relying on the video
that
recording.
is what they've said, that is not the minutes.
Okay, there.
I cannot stand in
Census suffering for the plaintiff, census suffering for the defendants. As per the counsel for the plaintiff has filed the supplementary affidavit by disclosing the transcript of the video recording dated 8 November 2024.
Violation of natural justice.
After serving the copy to the learned counsel for the defendants, let the same be kept with the record, not today. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear tomorrow. No, non-commercial है ना?
Their case of no violation of natural justice now goes.
No. This transcription will show in your predetermined notion that
That is
entire
not your
meeting.
case. That is not your case.
On 5th
That is not your case.
5th March as new motion.
5th
At
March.
the top. At the top.
Malad, could it be get some precision at the top, Malad?
At the top.
I'm sorry, man, I couldn't hear that, man. I'm so sorry. Because
Hey,
I'm
you
very,
are
very sorry.
appearing and there is no top.
I'm so sorry.
Heavyweight.
In
all sense.
Court has to run.
I'm sorry, man. I'm sorry.
In all sense, heavyweight.
So this is my application. This is
Yes. Vidyut Saraf.
This is my application under Order 7 Rule 11.
Who is for the other side?
Mr. Mitra was for the other side. This has been mentioned. Anyway, Lordship passes it over what to do.
Pass.
Lordship keeps it on another day. Next week it will come up, my lord, then. It's a non-commercial matter. They have filed a suit, my lord, seeking.
So appearing for the defendant. None appears. Defendant number 2 and 3.
Yes, my lord.
None appears on behalf of the plaintiff. Let the matter appear on 6th.
Very well.
6th
Great.
March. Under the adding new motion. Next.
Please, Your Lordship. May it please, Your Lordship, I was
My application.
I was addressing the maintainability.
They had
issue.
taken a demurrable issue. My lord, the property involved is a flat in a cooperative society. My suit is for partition and cancellation of a registered deed of gift. They take the point on the basis of 102 of the Cooperative Societies Act to say that there is an ouster of civil court jurisdiction.
May I
The
proceed?
question which had fallen from your lordship, well, just to remind your lordship, was even taking their argument at the highest, if the prayer for partition can also not be allowed, the prayer for delivery up and cancellation of a registered deed of gift, it inheres only with a civil court. Section 31 specific performance specifically is very clear. They were in the midst of making their argument. Let them say,
Okay.
I will give
My
it.
lord, a plaint, my lord, cannot be bifurcated, and a part of the plaint or a part of the claim cannot be rejected. If it has to be rejected, it has
As
to be
a whole.
rejected as a whole. This means that if I am able to, my lord, positively show before your lordship that a portion of the claim is either barred by law or there is no cause of action, then the entire plaint goes.
If suppose the other cause of action cannot be decided by any other authority, then
My lord,
what will happen?
then, my lord, this is exactly what has happened here. Two set of claims, and I'll show your lordship how they are interrelated as far as the plain statement goes. Two set of prayers. Prayer A is barred. Prayer B is rated with prayer A. Now the plaint has to be rejected as a whole, which means that they have to approach before the cooperative registrar of the society to get the prayer A moved before that alternative or before that authority. Once they get a sanction, they can then come up before this court with their assertion that cancellation and delivery up, that they are entitled to cancellation and delivery up. But what they are trying to do over here is, they have challenged, Millard, the mechanism of partition. They say that the defendants, in collusion with members of the society, housing society, have got all the shares transferred in the names of the defendant. Nomination. Illegal, according to them. That issue has to be tried, Millard, only by the authority under as Millard under section 102 of the Cooperative Societies Act. Civil court, Millard, is barred. That is very clear from the statute itself. Relying on this premise, they say that a deed of gift was executed by the mother in favor of the younger son, in favor of the elder son. Because the mother could never had got everything under the nomination, the transfer under the deed of gift is bad. Hence, cancellation and delivery. So there is a clear nexus between prayer A, or there is a clear connection between prayer A and prayer B. Now, if prayer A goes, then prayer B will also go. Millard kindly takes up the plaint. I have to quickly, Millard, show your lordship the paragraphs of the plaint, Millard. Millard, paragraph 1 of the plaint. Your lordship kindly sees the court's title, Millard. There are two plaintiffs.
The plaint enclosed with the...
No, it's not, Millard, there. It has... Your lordship, Millard, has the plaint, Millard. Last day we were showing, Millard, certain paragraphs from the plaint.
Yes.
Millard, there are two plaintiffs. And Millard, there are three defendants. Defendant number 3, Millard, is Latika Cooperative Housing Society. I am, Millard, representing defendants number 1 and 2. Now, if your lordship kindly sees paragraph 1.
You are for the defendant number
1 and 2. Yes.
Devraj and Reva.
Yes. Millard, Devraj is the elder son. Reva is the mother. Anjali Verma and Vikram Puri are brothers and sisters, and actually son and daughter of
all are
Reva.
the legal heirs of the Krishna. Keval
Yes,
Krishna.
Millard, all are legal heirs of Keval Krishna Puri.
Okay.
Millard, paragraph 1, plaintiff and defendant are related to
Defendant
each
number
other.
3 is the cooperative.
Yes, that is where the suit premises is located, of which partition is sought and cancellation delivery up is within jurisdiction. So it's actually a very renowned society, very renowned. Millard, paragraph 1 talks about, Millard, the genealogical table is there. Millard, your lordship can just have a look at the genealogical table. Page 18. I am not disputing this. Annexure A.
3. Yes.
Yes. So these are the three, Millard. As on date, there are 4 heirs of late Keval Krishna Puri.
Including wife.
Including wife. Including widow, Millard.
Yes.
Millard, paragraph 2. During his lifetime, the said deceased was the sole and absolute owner of a self-acquired flat measuring about 1,600 square feet on such and such place. That is the scheduled property. Paragraph 3. The said flat was acquired by the deceased on 28th day of March 2003 from Latika Cooperative Housing Society, the defendant number 3. Paragraph 4. The deceased resided in the said flat with his family members, that is the plaintiffs and the defendants herein. Paragraph 5. Late Shri Keval Kishan Puri died intestate on February 5, 2014, leaving behind the parties herein as his only legal heirs. Upon his demise, his estate, including inter alia, the said flat devolved upon the parties herein in equal shares. So this, according to the plaintiff, should be the share ratio. Paragraph 6. Though resident in USA and Canada, respectively until 2015, the plaintiffs visited the said flat whenever they visited Kolkata, being the residential home of the parties. Since the demise of their father, the defendants, particularly defendant number 1, elder brother of the plaintiffs, was trying to have exclusive control of the said flat. The defendant number 2, mother of the plaintiffs, due to her old age, being wholly dependent on the defendant number 1, had no other option but to surrender to the high-handedness and demands of the defendant number 1. Paragraph 8. The plaintiffs came to know that the defendants were attempting to deal with the said flat behind the back of the plaintiffs. The plaintiffs had written to the registering authorities calling upon them not to register the said flat in favor of third parties. None of the letters were replied to The plaintiffs reasonably believed that the matter rested there. Again, in or about second week of January 2024, plaintiffs came to know that the defendant number 3 has registered the said flat in the name of defendant number 2, excluding the plaintiffs and without the knowledge, consent and approval. Milord will kindly mark this paragraph. The plaintiffs, through its letter dated January 19, 2024, written by their lawyer, protested against such purported transfer or nomination. This is, Milord, an important paragraph as far as the prayer for declaration and partition is concerned.
Defendant number
3 is the housing society.
Has registered the said flat in the name of the
Defendant number 2. That is Revapudi.
Excluding the plaintiff.
Because Revapudi, Milord, had the 100% nomination.
Okay.
That is the admitted position.
So you might have been having the bylaws of your society with regard to the transfer of the shares.
Yes.
Of the members.
Of course, both parties must be having that. Both parties must be having that. But this is, Milord, their assertion that this has happened, that is defendant number 3 has transferred it in the name of the defendant number 2. Paragraph 10. Thereafter, in response to the above, the defendant number 3 by its letter dated February 17 for the first time disclosed that the alleged transfer by way of nomination has been done in favor of the defendant number 2 upon approval of joint registrar of the cooperative society. No copy of such written approval and or order referred to in the letter has been received or served on the plaintiffs. Prior to such date, the plaintiffs were completely unaware of such proceedings initiated before the joint registrar, nor was they put to notice thereof. The plaintiffs replied to the said notice dated February 17, 2024 by a letter of 29 February 2024. So this is also another allegation which they have, and they have that allegation against the joint registrar of the cooperative society as well. Paragraph 11, Milord. On making further inquiries, it transpired that the defendant number 2, through the defendant number 1, was using the said flat for commercial purpose, having converted the said flat into a guest house. Such change of user was also behind the back of the plaintiffs. The defendant number 1 and 2 have also obtained an enlistment certificate of KMC in respect of the said flat. It became absolutely clear to the plaintiffs that the defendant numbers 1 and 2, now this is an important paragraph, paragraph 12, 1 and 2 in collusion with the office bearers of the defendant number 3 have been trying to usurp the said flat by depriving the plaintiffs of their rightful share and interest therein. It became further evident that the act of treating the defendant number 2 as a nominee and thereafter allowing the change of user of the flat could not have been done by the defendants number 1 and 2 without the collusion and support of the members of the defendant number 3. The plaintiff engaged lawyers in Kolkata to cause searches to be made on their behalf with the office of the registrar. Upon such searches being made, plaintiff came across a deed of gift. This is the deed of gift, Milord, dated July 18, 2024, executed by the defendant number 2 in favor of defendant number 1. Paragraph 14. A perusal of the said deed of gift show that the defendants number 1 and 2 have intentionally and purposely concealed the fact that the plaintiffs have undivided shares in the said flat. Milord, I pause over here only to say.
This deed was executed by whom?
By the mother in favor of the elder son. That is by the defendant
after transfer.
After transfer. So the sequence is that the transfer is bad because according to the plaintiff, it should be 25% equal share, but 100% nomination was there in favor of the mother given by the father. The registrar of the cooperative society has transferred it completely in the name of the mother. This set of allegation, that is allegations till...
Yes, continue.
Yes. So that set of allegation to be tried under section 102 before the... Now, Milord, because of that set of allegation, paragraph 14 comes to play. A perusal of the deed of gift shows that the defendants number 1 and 2 have intentionally and purposely concealed the fact that the plaintiffs have undivided shares in the said flat. The defendant number 2, without the authority, consent and knowledge of the plaintiffs, have purported to transfer the entire said flat by way of gift to the defendant number 1. The defendants number 1 and 2 do not own the entire said flat. Kindly see, Milord, this is the tenor of the allegation, and are incorporated incorporated to deal with the same, the plaintiffs apprehend that the consent of the defendant number 2 has been obtained by undue influence. The defendants and each of them are active in collusion with each other and have perpetrated fraud. And then, my lord, page 6 is the particulars of fraud, my lord, pages 6 and 7.
Yes.
Now, paragraph 16, my lord, which is at the bottom of page 7.
Yes.
My lord, the defendants number 1 and 2 are acting in collusion with each other and trying to interfere with the right, title and interest of the plaintiffs in respect of the said flat. Thus, a decree for declaration be passed declaring the plaintiffs as undivided 50% share of the flat be passed. Now, my lord, in my most humble submission, my lord, this prayer could have been made if nomination was not done, or if they would not have challenged the nomination. Here, my lord, the plaintiffs are challenging the nomination because 100% nomination has already been done in favor of the mother. If that would not have been the situation, and if there would not have been any allegation against the defendant number 3, then perhaps, my lord, partition would have been maintainable. But since there is a dispute with respect to what allocation of share will be there amongst the parties, this issue has to be, my lord, tried by the appropriate authority, registrar, under section 102. So, my lord, this declaration is barred in my most humble submission. Yes. My lord, the bar is section 145. I'll show that.
No, where is the prayer? They have challenged that nomination, this transfer.
Yes.
In the prayer, they have not challenged.
No.
Then
they are saying that 25%.
They have to state the facts. What has happened? But in the prayer, kindly come to page number 11.
Yes.
Prayers, they have not challenged with regard to the transfer. They have challenged the deed. They have prayed for the declaration preliminary decree and partition and challenging the decree. They might have been disclosed the facts, what has happened, but they have not challenged the transfer is wrong.
My lord, may I make one humble submission, my lord? If your lordship kindly takes up, my lord, the specific relief act is section 34. That is declaration. A person asks for declaration when there is an infringement of his legal right, title or character. If there is no infringement, then a person will never ask for declaration. The fact that they have sought for declaration
Suppose,
is that there is, admittedly, there is this challenge to the right.
See, they filed this suit as a partition suit. They filed the suit as a partition suit, declaring the deed null and void and declaring that they are having the 50% share each. And 50%, 25% each. Correct. Suppose, leave aside this. If a property left behind by the father and the other party legally, illegally, whatever it is, or by way of a deed, transferred to the two brothers and two brothers are not got, or one brother is not, whether there is a bar.
There is the bar,
partition for declaration.
There is a bar with respect to section 102 read with 145 of the Cooperative Society Act.
Cooperative Society, that's why I'm asking again and again, sir. I am asking, they have not prayed against the society or against the registrar. They have narrated the facts, how the land has been transferred. That has to be, otherwise there will be suppression of fact. They have declared, but they have not kindly show me any prayer. They have asked for any prayer against the registrar or
I will show that. But, my lord, may I kindly invite your lordship's attention to section 102 once.
Section
My lord can have a copy.
Extract of the section.
102. My lord, there is a dispute. And since there is a dispute, my lord, they have added different number 3 as a party.
There is a dispute. If there will be no registered deed, if the registered deed had the registrar of cooperative society is having power to deal with the registered deed, declare as a null and void.
No.
Then?
But because, my lord, there is a complaint by them that there is a collusion by the registrar and the defendants number 1 and 2.
Maybe, but
because of that collusion,
on the final day, on the final day, there is a deed.
Yes.
That the registered deed.
Yes.
It is not that it is.
No, there is a deed.
That is
Yes,
a deed.
yes,
It is a registered deed.
Yes.
The registered deed cannot be set aside or declared null and void by any other authority than the civil court. Correct? It is a law.
Yes.
So if the deed is there, if they will file an application, settlement of dispute, what the register will do? It is a registered deed. What I will do?
May I, Millard, put it in this way? Millard, for them to prove that the deed is bad, they are relying heavily on a declaration that each one of them are entitled to 25%.
Correct.
So they, Millard, step one, first step is that they will have to prove that each one is entitled to 25%.
That's why the prayer A, preliminary decree.
That is, Millard, prayer A.
Prayer A, preliminary decree.
Until and unless they get prayer A, they cannot, and in no circumstance can they get the subsequent prayer for cancellation and delivery.
Correct. No
so the
problem.
prayer for cancellation and delivery is fully and totally dependent on the prayer, dependent on the prayer for passing of declaration in the manner they have sought. Unless they wholly succeed in prayer A, that is declaration and partition, they will not succeed in the prayer for cancellation and delivery up. Most certainly, Millard, cancellation and delivery up is not the scope and ambit of the registrar. The registrar does not have that authority to deal or declare any instrument of that nature.
Correct.
But similarly, Millard, a civil court does not have the authority to deal and declare disputed questions where societies are concerned, where
but they have not prayed any prayer. They have not prayed for any decree against the society.
Millard has
they
seen,
have prayed for their right of the 50% of share.
Millard,
and
Millard,
declaration the deed.
So your lordship, Millard, once again, there is your lordship has seen, Millard. Your lordship, Millard, has seen paragraph 9 and 10. Here, Millard, they have spoken of giving letters
Correct.
to the joint registrar.
Correct.
Also, Millard, paragraph 5 is there.
They are saying that
yes. Paragraph 5, Millard, is the first time they say that 25% each. Apropos that, Millard, if your lordship considers paragraph 9 and 10, there is, Millard, allegation.
Correct.
And then, Millard, most importantly, there is, Millard, paragraph 15, which I, Millard, now I think I should have placed. There is direct allegation, and this is not just setting out of facts, because particulars of fraud is there.
Correct.
So, Millard, they are saying that there is fraudulent action.
Correct.
Fraudulent action by which 25% has not been allotted to all of them.
Correct.
100% has been given to the defendant number 2.
Correct.
And because there is this fraudulent action, and there is, Millard, 9 instances of and particulars of fraud. Every part of it relates to actions of the member.
Correct.
That is exactly. I'll come to 102, Millard.
Correct.
So there is absolute, Millard, there is pinpointed allegation against the aspect of collusion and fraud. Based on that, Millard, they ask for the 50% share because they know.
Not based on the allegation. They made the allegation against you because you have deprived their right.
No.
You have deprived their right by way of a collusion. Otherwise, they are entitled to get the 25% share each.
Yes, I bow down, Millard.
Correct.
This is
so, and they have not asked for any prayer against your registrar, against your society. They have asked for the prayer for partition and the preliminary decree declaring that the deed of gift. Because how the deed of gift has come?
Millard,
deed of gift has come.
Because I have 100%.
You got the total property in your name. Who has got the property? Because of the defendant number 3.
Yes.
Because of the defendant number 3. So that's why they have made a different number. But where is the prayer? There is no prayer
Millard,
at all.
the first prayer.
Sorry, sir.
Millard, first prayer is couched in that manner. Millard, may I show your lordship 102? And I'll, Millard, also place
No, it will not affect. I am telling you. You show me. I am telling 102 is not affected in terms of your prayer made in the print, sir.
Millard, that is what is, Millard, Millard, if I may say, Millard, is something a hurdle which I have to cross.
Show me. That's I'm telling. I am telling that on the last occasion also you have made the same
Yes.
prayer because
Yes,
this
in
court
fact,
has gone through the prayers. If they could have been challenged, the transfer in the asking the declaration, the transfer is wrong. Then you might have been some point, but they have not prayed for any declaration with regard to the transfer in the name of the defendant number 1.
Milord, may I put it in this way? Whether they at all required to ask for declaration. If Milord, I am sailing with their
So
plane.
that's why they're directly
asked Milord that they are asking for declaration is, according to them, there is a dispute. Milord, kindly see section 34 of the Specific Relief Act once, Milord.
Yes, show me. Other, if the court will go by your submission, none of the participants will come in the court.
No, Milord.
Then
my humble submission is only, Milord, to
show me
assist your
34.
Lordship. Milord, kindly see, Milord. Section 34.
Yes.
Discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying
Correct.
or interested to deny
Correct.
his title to such character or right, and the court may in his discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. So, Milord, the very fact that they have sought for declaration shows that both the defendants number 1, 2, and 3, all of them, and there is particulars of fraud pleaded, are denying, not just interested to deny. They are denying the right.
Already denied.
Already denied.
Yes.
Now, if
So
it is
cause
already
of action arose.
yes.
So and what the cause of action arose? Because of the deed. And deed,
No,
the
Milord,
registrar
not just-
cannot. Your registrar cannot sit over the deed.
Milord,
Cannot
in my
change.
most humble submission, it is not just because of the deed. It is because, Milord, of the letters which they had given earlier.
Sir,
it began
see,
from there.
If the person has to approach authority, if the person approach the authority, can you say that they left? They cannot go to the suit. They made a prayer and they have made the averment what they have done.
Yes,
and
Milord.
find that the deed is there, so they file the suit for declaration and
But,
partition.
Milord, may I put it in this way? Today, Milord, if your Lordship is venturing to assess and determine whether the deed of gift was proper or improper, in my most humble submission, Milord, your Lordship will have to also determine whether the mother was entitled to 100% nomination.
So that cannot be in the interlocutory application where the deed is
I am,
under
Milord,
challenge.
Milord, I am
That has
talking
to be
about the-
proved by both the parties. You have to prove that deed is legal. They have to prove that deed is illegal. The interlocutory application, that deed cannot be said it is legal or
That is
illegal,
why,
sir.
Milord, that is
Sorry.
why, Milord, I am saying I have taken this point of maintainability where I am saying, Milord, that the suit is liable to be dismissed. I am, Milord, addressing your Lordship based on the final outcome. I am saying that the final outcome is not possible in the manner this suit has been framed.
That's why
Because
the
if
barred
you-
by law. What
Barred
is the barred by law? Barred by law is telling that they have made the averments against the society, against the registrar, which they cannot.
They have sought for a declaration.
Sought for the declaration, not against. Again and again, I'm telling, sir. Sought for the declaration, not against your society, not against your registrar.
Milord, I am not for the
Declaration-
society.
No, I am telling. You are telling that. Not for the society, not for the registrar. Declaration with regard to the deed. And again, I am repeating the deed. The registrar cannot sit over the deed. He cannot declare the deed null and void unless the
cannot.
civil court. Then
Milord, that is what I was saying, Milord, in the reverse situation, where your Lordship, Milord, will determine whether the deed is correct or incorrect.
That is a trial.
That is trial.
Correct.
At that time, Milord, before your Lordship, your Lordship will be inviting the parties to lay evidence on whether 25% is the correct ratio of shares or 100% nomination.
Correct.
A dispute, Milord, inevitably will come up where defendants number 1 and 2 will say that 100% is correct And already the plaintiff is saying that 100% nomination is incorrect. They are already taking that stand.
Correct.
So this, my lord, will be an issue before your lordship.
Correct.
And in my most humble submission, unless this issue is addressed, the bigger issue of declaring and cancellation and delivery up of the deed is impossible. So, my lord, this first issue, in my most humble submission, my lord, cannot be taken up by the civil court. Even if I take into consideration, my lord, the only declaration is sought where no dispute is against them.
Not to waste the court, sir.
My lord, kindly say.
I am
not
satisfied.
My lord,
not
kindly
sorry.
say the definition of dispute.
Sorry,
under section.
I am not satisfied. That act is not applicable. They have filed a suit here for declaration of the deed. What the averments you are praying, that is the facts they have disclosed. They have not asked for any relief.
I wanted
Sorry,
to
sir.
rely on a judgment. My lord.
Record and order.
My lord, this judgment is there. my
Sorry.
lord. If your
Half
lordship
an hour
kindly-
has given the time, but you are
No,
not
your lordship has
understanding
given me
the
more
law.
than half an hour. My lord. I only wanted to assist your lordship. My lord.
What?
I just,
Again, you are not understanding
my lord,
the law. What
I've
can be
understood-
done?
I have understood your lordship's point, my lord. I rest, my lord, whatever.
Mere filing in the application, you cannot waste the time of the court, sir.
But then I will stop here. My lord. I'll stop here.
This plaintiff has filed the present application. Defendants. Who has filed this?
My lord, this was my lord, my most humble submission, which I made verbally, my lord. My demurrer point, my lord, is on verbal submissions, my lord. I did not come up with an application.
This is my application, plaintiff's application.
Maintainability issue, my lord, I had raised at the very first stage.
Okay, rejected. Yes, then?
But my prayer.
Son suffering for the plaintiff, son suffering for the defendant. Full stop. The defendants all, defendant number one and
number
two.
1 and 2.
Defendant number 1 and 2 has raised the point of maintainability on the ground that the plaintiff has filed this suit making the allegation with regard to transfer of the property in question in favor of the defendant number 1 and 2 without following the due process of law by the society and the registrar of society. Full stop. The counsel for the plaintiff has drawn the attention, defendant number 1 and 2 has drawn the attention of this court to the averments made by the plaintiff in the plaint, wherein the plaintiff has sequentially made the averment what are the facts the plaintiff intend to narrate in the plaint, and how the property in question has been transferred in the name of the defendant number 1. Defendant number 1.
In favor of defendant number 1, yes.
In favor of the defendant number 1. Full stop. The counsel for the plaintiff, defendant number 1 and 2 is has submitted that as the plaintiff has challenged the action of the society as well as the registrar of the society, thus the suit is not maintainable. This court has gone through the prayer, wherein the plaintiff has made the following prayer: A to I. After going through the prayer, this court finds that the plaintiff has prayed for a declaration that the plaintiffs are having right title interest of undivided 50% of share in the flat. They have prayed for the preliminary decree and also prayed for a decree declaring that the alleged gift deed dated 18th July 2024 has been obtained illegally, fraudulently by the defendant number 1 in connivance with the defendant number 2 and the defendant number 3. Full stop. After going through the prayer portion of the plaint, this court finds that the plaintiff has not prayed for any decree against either the defendant number 3 or the registrar of cooperative society. The case filed by the defendant, filed by the plaintiff with regard to the declaration, partition, and declaration the deed as null and void. Considering the above, this court finds that the point raised by the defendants with regard to the maintainability is not cannot stand. Accordingly, the same is rejected. Yes.
your Lordship takes my application, well, I will not trouble your Lordship with the plaint. Your
What
Lordship has seen
application
the-
you filed?
Well, the application is for injunction to restrain the defendants from dealing with this property in the meantime.
Yes. Have you filed affidavit?
Well, the affidavits have not yet been called for because they raised this preliminary issue. Well, if they want to file an affidavit on the merits, they are most welcome to. But in the meantime, they should not deal with the property. That is the only interim order I'm praying for at the moment.
Yes.
My lord, I have shown your lordship the entire plaint, my lord. It doesn't disclose any need for an interim order.
You say that you are not transferring the further
I have already
property?
said that, my lord. I only beseech your lordship, my lord.
I am recording the submission.
There are two things, my lord. There are two things. Lordship can record it, but my lord, when I had told Mr. Dutt Learned Senior Advocate that I have told him, client is here, the mother is 82 years old, and the elder son is here before court. These two individuals, my lord, the plaintiff number 1 and 2, are staying outside Kolkata since 2015. They don't take care out of India. They don't take any care of their mother. If my undertaking is recorded, my lord, there will be one problem which I'm facing, and I'll be honest with your lordship. My lord, there is a paying guest house being run over there where
the court, I am filing with regard to the status quo with the nature and not to alienate.
Yes.
Yes.
Not to alienate.
But my lord, this should not be interpreted in a manner that the only bread earning method of paying guests
Status
should
quo
not.
as on date, and
That,
not
my
to
lord, that will create difficulty.
Okay, not to alienate only.
Not to alienate.
Not to alienate. Yes.
Not to alienate.
No, but
Not
PG business, my lord.
PG business, the court cannot restrain. What is there, what
I'm
that
deeply
is there.
No, not status quo. Because one PG girl, if she goes, another person comes, then that will be change of status quo, and there, my lord, will be a question of content.
What
So, my lord, I am undertaking that I will not be creating, I will not be selling it to anybody.
Prayer B, my lord, not to create any third-party interest or alienate. It is both covered. Prayer B.
No, not to create any third-party right or title. Interest, of course, is being created because there is PG who is coming and staying.
How is that
PG is not an interest,
That is, of course, an interest, my lord. I am taking money
PG
for
is not an interest.
It's a limited interest, my lord.
What interest?
She's
If I am in living in the PG, my interest has been
that
created over
limited
there.
interest only for 2 months or 3 months when you are staying there. Because this is my lord, highly contested. There is another suit which is pending. So this series of my lord, plaintiffs and defendants before the lordship, my lord, is second partition suit. This is the second
This court
one.
is totally understand.
It is
And it has to be proceeded further expeditiously.
Yes, my lord, I'm
You are
there.
the 85%, 85.
82 years old.
Then the
I'm the lady,
senior
my lord, and
citizen.
I'm representing the mother.
Your lordship sees, my lord, the conveyance. I haven't even opened the papers yet.
Yes, what is our submission
My
regarding
lord, will
injunction?
kindly record, my lord, my undertaking that I will not sell it to
The
anybody.
plaintiff, नहीं, वो तो बोल दिया. The plaintiff has filed an application being J1 of 2025 praying for interim order. Full stop. Counsel for the defendant number 1 and 2 in his usual submission submit that the defendant number 2 is running the said defendant number 1 is using the said premises as paying guest, and as such if at this stage an status quo order is passed, the same will be interpreted in other way, and thus the plaintiff and defendant number 1 will not be in a position to run the said business of paying guest. Accordingly, he prays that if an order is passed restraining that full stop. The counsel for the defendant number 1 and 2 submit that the defendant number 1 and 2 are not interested to deal with the property with any third party, and they will not alienate the said property till the disposal of the suit. In view of the submission made by the counsel for the defendant number 1 and 2, the defendants number 1 and 2 are defendants are restrained from alienating the suit property to any third party till the disposal of the suit. GA number so disposal.
GA1 stands disposed in that. Grateful. I'm obliged. I had no intention to will it take so much time.
See, this is go through the prayer. Yes, next.
Lord, from 12:20, your lordship, it's Lord, I'm being led by Mr.
Lordship
Bennett.
has mentioned in the list that the lordship will take up mentioning because there's a testamentary matter. Today is 3:30, I believe.
27th jurisdiction.
Oh, सब यहाँ आके खड़े हो गए.
Oh, he
Legal.
says that it has been mentioned wrongly. So.
No. Actual, what not today is the appellate side matter.
Yes.
So I told
3
him
PM.
I instructed 120. So department has taken as 11. No problem. Is all the parties are there. I will
Will I
take.
mention if your lordship grants me the
Give.
Your lordship sees the last order. There was the interim order is expiring today only.
Either 10 minutes here or 10 minutes there. No problem.
Item 56.
Who is for the? You are
This
for
is
the
item number
plaintiff.
56, your lordship.
You are for the plaintiff.
Yes, I am for the plaintiff. Your lordship
Who
will
is for
see
the
there is a
defendant. Anindya Lahiri.
defendant's on is a contested order. Interim order, if your lordship sees the page 2, the penultimate paragraph.
Or until further order.
Yes. 27th February until whichever is earlier. And your lordship, as per the last direction, we are filing our opposition. They have not filed their reply in
So suffering for the plaintiff. None appears on behalf of the defendants. Counsel for the plaintiff has filed. Affidavit in reply.
Affidavit in opposition in GA3 of 2024. Recalling
in opposition in connection with GA3 of 2024. Have you served?
Yes.
After serving the copy to the learned counsel for the defendant, let the same be kept with the record. Counsel for the plaintiff submit that interim order granted earlier is going to be expired today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 27th of March 2025 or until further order, whichever is earlier. Let the matter remain in the list.
Your lordship, it will appear on 27th, this matter.
Remain in the list.
Remain in the list. Your lordship, will also record that in spite of direction, they have not filed reply to the opposition. Time has expired by the defendant.
None person. Defendant, plaintiff. None appears on behalf of the plaintiff. None appears on behalf of the plaintiff and defendant. Yes.
My lord, item number 27, next item.
Yes.
There's some urgency in the matter, my lord. This is an ex parte injunction. Agreement for sale entered into, trying to put third party in the dwelling house.
What can be done? Bad luck.
I was just crossing my fingers, if you're lucky.
Come on to Wednesday.
Next
Wednesday.
Again, next Wednesday.
Huh?
Next Wednesday.
Because Monday, Tuesday is the commercial, tomorrow is the commercial also.
Oh, no, some difficulty, your lordship. My lord will fix this matter.
Fix, I will can only fix
because
in the
top position is now, any minute they will give position to a stranger in a dwelling house. I'm an octogenarian residing there.
Because today I don't find any time.
I'll take only 15 minutes of your lordship.
That's why I don't any time. If you wait, see if it can, I will get the time today, I will take, otherwise I will adjust some other time. Yes.
My lord, may I mention item number 30, my lord? This was appearing in my lord's list yesterday as item number 34. My lord, I had mentioned it for extension of interim orders, my lord. I find it is appearing...
34.
30 of today's list. This was appearing as 34 yesterday, my lord. I had mentioned the matter for extension
Central
of interim
Bank.
order. No, my lord. Babita Khetan.
30.
30 of today's list, my lord.
30, yes.
Yes. So, my lord,
31.
yesterday I had mentioned it for extension of interim orders, my lord. Order has not yet been uploaded. I find the matter is again appearing in the list today.
Yeah, it will take, you will get the order today.
Please, my lord. Most grateful.
My lord, item number 28. I'll trouble my lord. Yesterday also I said that if it can be taken up, lordship said it would be. Since it is not, can it be fixed on my lord tomorrow or on Wednesday, my lord?
Now Wednesday it will come on the same list.
Your lordship,
My lord,
28.
my lord, 28.
They're trying to move it expert. I got to know from the
No, very well. Very well. If Mr. Banerjee is there, if
It's
Mr.
urgent.
Banerjee is there, my lord, if Mr. Banerjee is there, I'm so happy, my lord. Let him be there. I'll be happy to have him. My lord, can it be, my lord, on
Let them serve. That is what I'm asking.
my lord, I will serve even. Can it be on Wednesday at the top, my lord? That is exactly what I, because lordship gave me that liberty.
Wednesday will call if the item number 26, no, Mr. Mr. Anirban Basu. 27 and 20, you are in 28. Both will
Yes, my
come
lord.
one after another on that day.
So, my lord, I am assured that I can address my lord on that.
Yes.
Grateful, my lord. Great.
In the meantime, they will serve. We will write to them.
Yes, other copy.
Yes. I will serve on. I'm so happy that they've come up.
Very agreed with the allotment of the criminal matters, not your lordship. Lord, we complained in writing to the chief justice.
Sorry.
My lord, this is a case of
He wrote, my lord, to the Honorable Chief Justice saying that we all, anyways, my lord, your lordships have so much pressure, and this additional pressure, my lord, is really depriving us.
Mr. Sinha is not able to say it, my lord. This is a case of love lost, my lord, which my lord should not exercise on us.
The other bar members also.
Well, your lordship had no love towards them, but lordship had and lordship lost it. That is why we are crying. Grateful, man.
Yes. अच्छा हाँ जी हाँ जी yes sir.
Well, your lordship has seen the judgment, my lord, which has been delivered, which I got hold of only yesterday. I mean, the judgment of the coordinate bench. Well, I've got a lot of things to say about it, but then again, my lord, the only thing is this: your lordship will kindly look into it.
Yes.
The court has held that by reason of the City Civil Court Act, the testamentary jurisdiction of the High Court under clause 34 had been totally lost. Your lordship kindly sees in respect of matters to which, my lord, the City Civil Court Act applies. Page number 4, after discussing this, the court says the last few lines, paragraph 3, last few lines at page 4.
Yes.
After the City Civil Court Amendment Act 1980, the High Court, that is this court, cannot exercise its jurisdiction by virtue of clause 34 of the latest patent 1865 in cases of testamentary and intestate jurisdiction in respect of the matters arising exclusively within the territorial jurisdiction of the City Civil Court. That is to say, where the deceased had a fixed place of abode within the ordinary original civil jurisdiction of this court, and all his assets and properties were also located within the jurisdiction. Now, I pause here for a moment, my lord. In this matter, in which, my lord, this judgment has been delivered, my lord, I was appearing for the petitioner. To some extent, my lord, I am interested in getting the probate done in this matter. Now, kindly see, here it says, unfortunately, my lord, the learned judge, my lord, did not look into the facts of this particular case. It says that in respect of matters arising exclusively within territorial jurisdiction of the City Civil Court, that is to say, where the deceased, well, the page 4, the last few lines. After, my lord, considering these two judgments,
yes,
it says that the last few lines, yes, the court clearly held that after the City Civil Court Amendment Act, the High Court, that is this court, cannot exercise its jurisdiction by virtue of clause 34 of the latest patent 1865 in cases of testamentary and intestate jurisdiction in respect of matters arising exclusively within the territorial jurisdiction of the City Civil Court. That is to say, where the deceased had a fixed place of abode within the ordinary original civil jurisdiction of this court, and all his assets and properties were also located within such jurisdiction. Well, my submission had been that in this particular case, in the case of my lord, the goods of Pravi Chandra Sen, there, my lord, the place of abode of the deceased was, my lord, outside jurisdiction, original jurisdiction in Baliganj. The property, one was in Baliganj and the other was in Delhi. All the heirs and legal representatives had signed the probate application, consented to it. So my submission had been, if your lordship looks into section 283 of the Indian Succession Act.
Succession Act.
আমাকে ইন্ডিয়ান সাকসেশন অ্যাক্টটা কোথায় গেল?
এই যে আপনাকে দিয়েছে
Lordship, will kindly see section 283. Well, my submission has been very simple. I think Lordship forgot, my lord, what I submitted. Okay. Later. Kindly, my lord, take section 283.
Yes.
In all cases, the district judge or the district delegate may, if he thinks proper, A. Examine the petitioner in person upon oath. B. Require the further evidence of the due execution of will or the right of the petitioner to the letters of administration as the case may be. C. This is the one. Issue citation calling upon all persons claiming to have any interest in the estate of the deceased to come and see the proceedings before the grant of probate or letter of administration. Now, kindly note this. The words are very significant. In all cases, the district judge or district delegate may, if he thinks proper, this is a discretionary thing.
Correct.
Issue citation. Now, my lord, my submission had been this, that this is a discretionary thing, can issue citation. But if all the heirs and legal representatives, my lord, consent to it, then, my lord, chapter 35 of the High Court rules comes into operation. There, my lord, no citation need be issued if all the heirs and legal representatives. Then, my lord, kindly come to subsection 3. The subsection 3 is, my lord, on which, my lord, the learned judge has passed this judgment. Where any portion of the assets has been stated by the petitioner to be situate within the jurisdiction of a district judge in another state, in our case, my lord, in Delhi, a flat was situated. The district judge issuing the same shall, here, my lord, the imperative shall, cause a copy of the citation to be sent to such other district judge who shall publish the same in the same manner as if it were a citation issued by himself, and shall certify such publication to the district judge who issued the citation. Now, I pause here for a moment. My submission had been very simple. I said that subsection 3 will come into operation only if, my lord, the original court has directed issuance of a citation. If, my lord, by reason of the rules, by reason of the procedural rules, no citation had been issued or directed to be issued by the first court, then, my lord, there is no question of copy of the citation to be sent. But kindly see the language. A copy of the citation to be sent to such person. Copy, that means a copy of the citation which has been issued in terms of 283(1)(c). So, and, my lord, your lordship has been pleased to see that insofar as chapter 35 is concerned, rule 1 read with rule 9. Chapter 35, rule 1. Non-contentious business shall include the business of obtaining probate and letters of administration with or without will annexed, and whether general, special, or limited, where there is no contention as to the right thereto, including the passing of probates and letters of administration through the court in contentious cases where the contest is terminated, and all ex parte business to be taken in the court in matters of testacy and intestacy, not being proceedings in any suit, and also the business of lodging caveats against the grant of probate or letters of administration. Then now, my lord, kindly come to rule 9. On an application for letter of administration, I am also, my lord, application for probate, unless otherwise ordered, a citation shall be issued to all persons having a right to take the grant prior or equal to that of the applicant, unless such persons have signified their consent to the application. So once, my lord, these persons to whom the citations shall be issued in terms of rule 9 had agreed, had signified their consent to the application, and no citation need be issued. If no citation need be issued, 283(1)(c) doesn't come into operation. If 283(1)(c) does not come into operation, subsection 3 doesn't come into operation, because no citation is issued, so no copy of the citation will be there. This was my simple submissions before the court. I said that look into the rule section, look into the rule, and kindly come to the conclusion that subsection 3 of section 283 does not arise in the facts of this case. But well, this has been not been, the court had gone into a discussion as to the law on the subject. But that application of the law has not been. But I tell you, Lordship, very frankly, I have advised my client in that matter in which I was appearing in the trial court to go up in appeal. Because, my lord, this is going to create a lot of problems.
That is the problem, because when I have been given determination, yes, come with that. Otherwise, now the court has, I am not aware of this order. Then I am passing an order instead of the citation. I am passing an order with regard to the publication.
That's right, Your Lordship. I've seen that order. But my respectfful submission will be that looking into the facts of the particular, if, my lord, no, the property is not situated within city civil court jurisdiction, that is, my lord, the original jurisdiction of the High Court, and, my lord, there was the residence of the abode of the person, testator, was not within jurisdiction, then, my lord, respectfully submit, the City Civil Court Act does not apply. Then clause 34 comes into operation. You cannot abrogate letters patent altogether. You can do that. My lord, that's, Your Lordship will kindly see.
So appeal is not preferred.
Appeal, my lord, this judgment has been only handed over yesterday. So, my lord, I have already instructed, my lord. I think
16
that
January, latest.
Therefore, my lord, today, since Your Lordship has been kind enough to appoint me as the amicus, now Your Lordship has got a judgment. So, I mean, honestly speaking, Your Lordship cannot differ from it, being in the coordinate bench.
Correct.
The only thing that can be done by Your Lordship, if Your Lordship does not agree, to refer it to Honorable Chief Justice for constituting a larger bench to discuss this. Or the alternative is, I go up in appeal, so that the matter can be.
Because latest order you can prefer an appeal, that will be better.
We are going to do that. Therefore, I am submitting to Your Lordship today. I think I have got a very substantial point to argue.
Correct.
And I refuse to accept, my lord, that clause 34 of the latest patent of this, my lord, vintage origin. Completely you abrogate that. Yes, you can. It can be abrogated. I don't say that it can't be abrogated, because clause 34 says so. If Your Lordship sees the clause 34 has been quoted at page 3.
Yes, it is there.
But this is an interesting argument. Kindly come to page 3. Clause 34 has been quoted. Testamentary and intestate jurisdiction. And we do further ordain that the said High Court of Judicature at Fort Williams in Bengal shall have the like power and authority as that which may now be lawfully exercised by the said High Court in relation to the granting of probates of last will and testament and letters of administration of the goods, chattels, credits, and all other effects whatsoever of persons dying incested, whether within or without the Bengal division, kindly note the words, of the presidency of Fort Williams, provided always, kindly, my lord, this is that the nothing in these letters patent contained shall interfere with the provisions of any law which has been made by competent legislative authority for India, by which the power is given to any other court to grant such probates and letters of administration. So, my lord, clause 34 itself conceives of a situation that a legislation can be formulated which will abrogate the power which has been conferred under this. Correct. Now, City Civil Court Act, my lord, has come into existence, and there the City Civil Court Act jurisdiction has been enumerated as to what it is and what it should be. Your Lordship kindly takes, my lord, section first, kindly take section 2. Section 2 definition, subsection 3. City of Calcutta means the area comprised within the local limits of for the time being, of the ordinary original civil jurisdiction of the High Court. So, my lord, the rest is limited. So, then, my lord, kindly come to section 5, jurisdiction. The local limits of jurisdiction of the City Civil Court shall be the City of Calcutta. Then, subject to the provisions of subsections 3 and 4, the City Civil Court shall have jurisdiction, and the High Court shall not have jurisdiction to try suits and proceedings of a civil nature, not exceeding rupees 10 lakhs in value. And then, my lord, proviso has been added with regard to concurrent jurisdiction. Provided that the City Civil Court and the High Court at Calcutta shall have concurrent jurisdiction to try suits and proceedings of a civil nature of the value of which exceeds rupees 10 lakhs but does not exceed rupees 1 crore. This particular amendment has come into existence in 2013. So one will have to see as to when the application was made. I am not going to trouble your lordship. Kindly come to subsection 3. The City Civil Court shall have jurisdiction and the High Court shall not have jurisdiction to try any proceedings under, kindly come to Roman 4, the Indian Succession Act 1925. So, my lord, my submission is this, that by this provision, there had been to some extent and had been enrolled into clause 34. To the extent, my lord, the last few lines, where it says that these legislative content shall interfere with the provisions of any law, shall not interfere with the provisions of any law which has been made by competent legislative authority for India.
Which
By
power
which
is
power?
given?
Well, clause 34 of the last few lines.
Yes, which power is given to any other court?
So this power has been given by City Civil Court Act. So I cannot contend that this clause 34, the jurisdiction under clause 34 of the latest patent, continued to remain as it was prior to the City Civil Court Act. By reason of this, that portion of the jurisdiction has gone out. Which portion? The portion with regard to the property of the testator is within the jurisdiction of the limited jurisdiction of the High Court. That is what it says. Try suits and proceedings of civil nature not exceeding rupees. And my lord, the jurisdiction is the local limits of jurisdiction of City Civil Court shall be the city of Calcutta. Now, if your lordship finds the property of the testator is lying in Baliganj, it is outside the jurisdiction. If your lordship finds the testatrix, the testator's heirs and legal representatives are all outside jurisdiction. So, City Civil Court jurisdiction out. If City Civil Court jurisdiction is out, then clause 34 comes back.
The court.
So this court will have jurisdiction. This was my short point. And I said that once this court has jurisdiction, then, my lord, the rules, chapter 35 comes into operation. Chapter 35 specifically says,
Rule 9.
Rule 9, you don't have to issue a citation. And if you don't have to issue citation under Rule 1C, then sub-rule 3 doesn't come into operation. This was my simple argument. But anyway, my lord, there are judgments there. In fact, in 2018, Supreme Court has delivered judgment. Unfortunately, your lordship can see this Lynette George's judgment, which have been Supreme Court judgment. This court, kindly come to page 14 of this judgment.
Yes.
First, second, third, fourth, fifth, sixth line. I am unable to accept the ratio laid down in Lynette Fernandez. As at the revocation stage, it may, on consideration of the facts of the case, the court may find none. Therefore, I do not accept the ratio laid down, and kindly see, my lord, Lynette George's Fernandez's case is reported in 2018 one Supreme Court cases, page 2, the earlier page. 2018 one Supreme Court cases, 271. The learned judge, what he said was that Lynette Judge did not take note of 2008 one Supreme Court cases, page 267. And my respectful submission was that his lordship did not read, with the greatest of respect, correctly read my lord Bashanti Devi's case. So, my lord, what he said is this: I am not bound by the subsequent judgment of the Supreme Court of 2018. This perhaps was not.
Because that's why now, after that, I got this judgment.
That's
the
right.
2018.
That's right.
So when I call Mr. Vettel, no, it has to be deliberation is required.
And therefore, my lord, I will submit to your lordship 2018 judgment is binding. Bashanti Devi's judgment 2008 is also binding. But difference between the two, I shall just indicate to your lordship. 2008 one Supreme Court cases was talking of 283 1C.
Yes.
283 subsection 3. It was talking of this, and there the court said that once the citation has been issued under 283 1C, then it becomes mandatory under subsection 3. Because, my lord, language of subsection 3 is shall. the district judge in another state, the district judge issuing the same shall cause a copy of. My lord, so far as one is concerned, it is not mandatory. So far as subsection 3 is concerned, it is mandatory. So once citation is issued by the original court,
then it has to be complied with. It has to be complied.
This is what my lord Bashanti Devi said. And Lineage George said, so far as one is concerned, subsection 1, this is the district delegate may, if he thinks proper. So that judgment had interpreted the first part of 283 and said that this, my lord, is a discretionary order. It may issue, it may not
issue.
But in Lynette Fernandez's case, what happened was this: the person concerned was within jurisdiction. The heirs concerned were within jurisdiction. Property concerned was within jurisdiction. Only one property was in Chikmagalur.
Correct.
And there, the court said that it is not necessary because the original court did not issue a citation in respect to the heirs and legal representative. So, since it was not so issued, it is not. There is no infirmity.
3 will not come.
This subsection 3 will not come into operation. So, my lord, these two did not militate against the submissions I made. My submission was in consonance with
this court is binding.
Yes, my lord. So I will.
Let us see. I am adjourning for
yes, I very
the time
respectfully
being.
submit to your
See
lordship
if it is there.
yes,
Otherwise,
if
then
the judgment is there, your lordship will be. I will not request your lordship to differ from the judgment and refer it to that. I think, my lord, your lordship should wait. Let me prefer an appeal. Let me see, my lord, what happens there.
That will be better.
I think that.
Share also all consent. All consent. আমার মামলা সব consent আছে।
Ultimately, it's only so. Appearing for the petitioner, Mr. Jayanta Kumar Mitra, learned senior advocate, with Mr. Subhasis Sen Gupta, learned advocate, appearing as amicus curiae appointed by this court. Full stop. Learned senior counsel has argued the matter at length, but he has also referred to the judgment passed by the coordinate bench of this court in PLA number 115 of 2023, dated 16 January 2025, which involves the same issue which is in the present matter. So the learned senior advocate submitted that the petitioner of PLA number 115 of 2023 is going to prefer an appeal against the order dated 16 January 2025. Accordingly, for the time being, the case is adjourned. Let the matter appear on 26th of March 2025. Take this book.
This is my application. I had applied for grant of letters of administration, Your Lordship.
89.
Your Lordship takes up the last order, dated 6th of February 2025.
Yes. According to counsel for the cavities, the directors of the
They had appeared for the first time. They had stated that they have filed an affidavit in support of the caveat. And accordingly, Your Lordship asked me to hold my hands till they serve the affidavit in service, so that Your Lordship can suitably classify the matter and thereafter pass the other interim order that I was praying for. Now they have served me the affidavit in support of the caveat. Now,
for the respondent number 1 and 2.
very well. Now, if Your Lordship has a copy of the affidavit in support of the caveat in front of Your Lordship,
affidavit
this is affidavit in support of the caveat in PLA number 358 of 2024. Your Lordship will kindly take that affidavit in support.
Yes.
Your Lordship will see the contents of the affidavit just briefly at page 3. No grounds of objection are taken.
The applicant is said the applicant as one of the executors.
The applicant is one of the executors. Your lordship is reading which paragraph?
Paragraph 5, page 3.
It's absolutely incorrect. It's a letters grant for letters of administration. There is no probate. There is no will. This is not a probate proceeding.
One of the executors and being filed caveat to contest the present letters of administration proceeding. Who has filed this affidavit, madam? Preeti Jawar and Pramila
Preeti
Jawar.
Jawar and
Pramila Jawar.
Yes, the caveatrix, your
Both
lordship.
are the caveatrix.
Yes.
is the elder daughter and wife. And I'm the younger daughter, Shruti Jhawar, who had taken out the application for grant of letters of administration.
What is the ground?
No ground is disclosed.
What is the ground in
And
the
your lordship,
affidavit?
under 2425, if the affidavit in support in caveat does not disclose the grounds of objection for non-grant of the letters of administration, it does not even qualify to be a affidavit in support of caveat. So it cannot be marked as contested. I will, if required, not to detain your lordship, if required, I will file a suitable application for discharge of this.
That is the way. Otherwise the
Absolutely.
court
I
will
have
not.
just received it. And my second submission is I will seek discharge of caveat and to proceed with the PLA. The second submission, your lordship, as I had earlier also insisted, prayer A had been granted because certain number of shares had been transmitted to Preeti Jhawar. In
Yes.
view of that fact, prayer A had been granted, injuncting all the heirs. But prayer B, the details and particulars have to be furnished, your lordship, and they have not filed any opposition.
Your lordship will file the opposition. The,
No,
But you can file. But what the caveat you have filed?
the matter is, I have no interest in like, I have no instruction about that. I have only instruction that will file the
Your lordship will recall.
What's your good name?
file the
What is your good name?
Disha Roy, your lordship.
Who is Mr. Aptabuddin?
He's
Last order
he's
to
the
record.
advocate on record, your lordship.
Your lordship, not to embarrass my learned friend, I will state something. The respondents never appeared in this matter. They appeared for the first time on 6th of February. And one Mr. Akash Datto's name has been recorded as the person appearing for the caveatrix. He appraised your lordship that they have filed upon instruction. And he stated that he is going to serve, and we have been served with the affidavit in support. So in these circumstances, the affidavit in support of the caveat is on record. There is nothing further that needs to be looked into.
Sons appearing for the petitioner, sons appearing for the caveatrixes. Full stop. Counsel for the and the caveatrixes have filed their affidavit. Is on.
Your
Okay.
Your lordship.
Have filed affidavit in support of caveat. Caveat after serving the copy to the learned counsel for the petitioner. Full stop. Counsel for the petitioner prays for time to take appropriate steps for discharge of caveat. Accordingly, cases are adjourned. Let the matter appear on 19th March.
Insofar as my GA is concerned, your lordship will kindly see prayer B. Because they have been refusing to file the affidavit in opposition in the GA, the details and particulars of the assets that has already fallen into their hands is not coming on record. Prayer B is at page 11. It's an innocuous prayer. There is already an injunction. There is admitted transmission. All we are seeking is disclosure of the status of the transmitted shares at prayer B.
But
and 6 months, more than 6 months have
Your
passed
lordship will file
since
it
the first
in the
order.
next hearing. Actually, the respondents are out of station. That's why your lordship was saying for
That's
that.
Calcutta based.
Okay, let they come on.
Your lordship, may I suggest one thing, lordship, with the deepest of respect, not to labor upon this. Your lordship will pass a direction upon them to file an affidavit in opposition, disclosing the assets.
If you file an application, it will automatically be served. Let the other, because he's a juice.
Let this be made peremptory in that respect, so that on the next occasion.
Come on that day, you will file an application.
I usually do not labor upon these things, but this has happened on multiple occasions.
Correct.
Let it be peremptory on this occasion.
What peremptory?
That if they do not file the opposition, I will press my prayer B.
So counsel for the petitioner pressing for hearing of the interim application being GA1 of 2024. Counsel for the caveatrixes press for extension of time to file affidavit in opposition. For the interest of justice, time to file affidavit in opposition is extended for a period of 1 week from date. Full stop. It is made clear that if on the date fixed within 1 week, the caveatrix has failed to file the affidavit in opposition in connection with GA1 of 2024, the interim application will be taken of hearing without the affidavit.
I'm very deeply obliged, Your Lordship.
Next.
I'm deeply obliged.
90, my lord, this is my application for extension of time to file extension of time to file inventory and account.
Inventory, and when the order was passed?
The order was passed on 10/11/2022, my lord.
2022. And when the probate was granted? Issued
on 7th January 2023, my lord. My lord, considerable time was
why you not filed the inventory and accounts?
My lord, the reason is that for the purpose of mutation, my lord, for the purpose of mutation, my lord, certain documents were required, my lord. That was missing, my lord. We made a total search of it, and then the mutation could be completed, my lord.
When the mutation was completed?
Mutation was completed.
You not mentioned the date.
Date I have not mentioned.
Then you not mention the date. So appearing for the petitioner. The petitioner has filed the present application, praying for extension of time to file inventory and accounts in connection with PLA 375/2021. Counsel for the petitioner submit that the probate was issued on 7th of January 2023. After the issuance of the probate, the petitioner has taken appropriate step for mutation of the property, but it took time, due to which the inventory accounts could not be filed within the prescribed time. Considering the submission made by the counsel for the petitioner, for the interest of justice, time to file inventory of accounts is extended for a further period of
10 days, my lord. I prayed for
2 weeks from date.
Grateful.
GA number so disposed of. Next.
91, my lord. Application. My lord, we used to withdraw this application, my lord. But there's been a grave mistake.
What application you filed?
My lord, this is, we could not file the caveat on this affidavit in support of the caveat within time, my lord. My lord, that's why we're seeking a condemnation, my lord. My lord, in that application, my lord, the petitioner's son and wife, my lord, was suffering from chickenpox and another was suffering from shingles, my lord. My lord, we have written in the application that he was suffering from chickenpox and shingles. That's the difficult. My lord, we used to withdraw this, my lord, file afresh within a week, my lord.
So suffering for the caveatrix or caveator?
Caveatrix, my lord. Caveator.
So suffering for the caveator. Who is for the petitioner? No.
I am for the petitioner. My lord, I've got nothing to say, my lord. This is a formed application, my lord. I don't know how it has been applied.
What has
that way.
Just suffering for the petitioner, so suffering for the caveator. Counsel for the caveator has filed an application being GA1 of 2025, praying for extension of time to file affidavit in support of caveat.
Caveat as well as affidavit.
Caveat also. To file caveat as well as affidavit in support of caveat. Counsel for the petitioner's caveator submit that there are technical defects in the application filed by the caveator. Accordingly, intends to withdraw the same with the liberty to file afresh. Consider the submission made by the counsel for the petitioner, GA number 1 of 2025, is dismissed as withdrawn, liberty to file afresh. Next.
This is my application seeking compliance of section 283 subsection 3, my lord. Here, my lord, general and special citation have been completed, my lord. Only one property is at Bikaner, my lord. Page 53 kindly takes up, lordship.
Page
53.
Affidavit in support of master summon. What are you afraid for?
Compliance
General
with section
citation
2,
issue to
general
publish.
citation, the normal the section, but my lord, if your lordship permits me to make a newspaper publication,
Page 52.
Page 53, my lord.
53.
53
No, the
Roman one.
paper publication time has gone. Now the coordinate
Lord, I
bench
have-
has passed some order.
That's
That is binding upon me.
I have seen that, your lord.
Yes.
It in Bikaner, my lord. 53 Roman 1, my lord. Page 53 Roman 1.
53 Roman 1. Residential
Residential
2
house in
stories. Bikaner.
Bikaner, my lord, yes.
Yes.
And in page 50 also, my lord, there are some LIC policies which is in Bikaner, my lord. Page 50.
50. Which serial number?
Serial number Roman 3 and Roman 4. Takes up page 50, my lord. It's
50.
50, 50.
Roman 3, Roman 4. Bikaner. Bikaner.
It's
Yes.
in Bikaner, my lord.
So appearing for the petitioner. The petitioner has filed the present application being GA3 of 2025, praying for issuance of citation in terms of section 283 within bracket 3 of the Indian Succession Act on the ground that one of the landed residential house and insurance policy, two insurance policies are situated outside the jurisdiction of the state of West Bengal and are situated at Bikaner, Rajasthan, state of Rajasthan. Consider the submission made by the counsel for the petitioner, peruse the details of the assets of the testator, prayer A and B of the master summon is allowed. GA3 is disposed of.
Lordship, I appear on behalf of the applicants. This is again another amendment application, this time in green ink. Green ink, second amendment. Your Lordship, this was originally an application for letters of administration.
Amendment of the original application of letters of administration, proposed amendments submitted. Yes, disposed of. Then,
Your Lordship, the letters of administration has been granted. But thereafter, we have noticed there has been one mistake which went unnoticed. That is the affidavit of assets had not been amended.
Affidavit of assets were not amended.
Yes, it was given by one of the applicants. It had to be given by all of the applicants. We had taken out an application for amendment of the original application.
Only including the name.
Yes, Your Lordship will kindly look at the proposed amendment. It starts at page 11.
Suchitra Basu.
Yes.
The name is to be deleted.
Yes, one of the applicants, she had passed away. That is why the amendment was effected. After filing the application, she passed away, and the other three people had to be implemented.
So where is the grant?
The grant is at page 7.
Not enclosed.
Your Lordship, sorry, my mistake. Page 10.
Not completed.
No, cannot be unless the affidavit of assets is.
Who was the original petitioner?
Original petitioner was Suchitra Basu.
At the time of grant of probate, the letters.
No, at the time of grant of probate, the other three parties which are being proposed to be incorporated in the affidavit of assets, they had come in place instead of Miss Suchitra Basu.
At that time, you have not amended this.
Correct.
But the probate application was amended.
Yes, it was amended. This is in green ink. That is why I brought it to your notice of Your Lordship.
Consensus appearing for the petitioner. Petitioner has filed the present application being GA2 of 2025, praying for amendment in the affidavit of assets. The counsel for the petitioner submitted. Initially, the petitioner has prayed for amendment in the probate application, and the same was allowed by an order dated 1st of May 2024. Subsequent to the amendment, this court by an order dated 2nd August 2024 has granted probate. Letters of administration probate has granted
letters of administration.
Has granted letters of administration.
Your Lordship, we also find the order at page 6, which allowed my first application.
Yeah, that's how you recorded.
Yes.
Application was allowed. The amendment in the proposed application. क्या बोला ऊपर में? First, the census appearing for the petitioner. Praying for amendment in the affidavit of asset. Full stop. Prior to क्या बोलो उसके बाद क्या है? हाँ? In the probate application, in amendment in the letters of application filed for grant of letters of administration, comma, the same was allowed by an order dated 1st May 2024. And subsequently by an order dated 2nd August 2024, this court has granted letters of administration. Full stop. After the grant of letters of administration, when the department has processed for the issuance of letters of administration, comma, it was found that the petitioner has not amended the affidavit of assets.
Inadvertently.
The petitioner inadvertently has not amended the letters of the affidavit of assets. Accordingly, the petitioner has filed the present application. Had the learned counsel for the petitioner produced the materials on record and the application, this could find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the application. Accordingly, prayer
A to C, Your Lordship.
A, B, and C of the master summon is allowed.
In fact, Your Lordship can also record that the surety bonds have also already been furnished with the department. Because at the time of that we came to this
That's why at the time process of issuance of letters of admission.
But that steps may be taken in accordance to the order dated 2nd of August.
After the amendment is carried out, comma, the department is directed to take appropriate steps in terms of the order dated 24th of August.
2nd of August.
2nd August 22.
Grateful.
Disposed of. GA2 is disposed. Yes, next.
Please, Lordship. It's my application.
Yes.
The deceased was a very popular member of the society. He died at the age of 94. He had a first wife who passed away about 53 years back.
About?
53 years back. Died issueless. Then he remarried, and the second wife also died, and he had no issue.
Second wife also died.
Died, no issue. Now he has given entire of his property to charitable trust.
Charitable trust.
Charitable trust. Entire property, entire estate. Now my prayer today before your Lordship is twofold. Number one, that I do not have the death certificate of the first wife. We tried to locate that. It is more than 50.
When she died?
She died, my Lord, I'll tell your Lordship, in 1975. And she possibly died in Breach Candy Hospital, Bombay. At that time, there were no computers. They have tried with their very best to obtain the death certificate, could not get that. So, my humble prayer is this, that kindly dispense with the production of the death certificate of the first wife. Second wife death certificate is the next. Both have died issueless, my Lord. And my Lord, entire property he has given to the charity. Now, I want, prayer one would be that kindly grant me exemption from filing the death certificate, and I want issuance of citation. If your Lordship kindly takes my prayer on page 6, my Lord. Requirement of death certificate be dispensed and be directed to proceed further without certificate. And then I want special citation, general citation, and publication of general citation in newspapers, and copies of general citation to be sent to Dhanbad, that is Jharkhand, Kutch, Gujarat, and the registrar original site at Madras below for publication in terms of section 283(3). This is my humble prayer below. Nobody is going to be prejudiced, no one is going to be affected. We have made best of the efforts to get the death certificate of the first wife, we could not get it.
When you file the PLA?
PLA was filed, I'll tell you, Lordship, Lord. That's of 2023, Lord. They were filed on, I'll tell you, Lordship, 13 December 2023.
Yes.
And we have been making genuine attempts, but could not get it. And the department scrutinized, and we have very clearly mentioned in the will that there was a first wife. We also mentioned there was a second wife, first wife predeceased.
In the will, it is mentioned the first wife predeceased.
Yes, yes. Lord, in the will itself mentioned. If your Lordship kindly takes.
Where is the will?
I'm giving you, Lordship. Kindly see page 24. Here the will begins, my lord. And then he has, of course, appointed his elder brother's two daughters as executrices. And he made a declaration establishing irrevocable charitable trust, known as so-and-so, which is duly registered under Section 12A of the Income Tax Act. And then, if your Lordship turns
So he has appointed the trust executrixes.
Yes.
As trustees.
Yes.
Correct.
That is true. That is true. But it's for charitable purposes. No benefit to anybody, my lord.
Yeah. Declaration trust established William. Yes. Then
my lord.
Where is the averment that first wife died?
I'll give you, Lordship. If your Lordship kindly takes page 2, paragraph 2A.
Paragraph 2A.
2A.
Of the will.
Page 2 of
the will.
Page 2.
In the will, whether he has mentioned.
Yes, 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 my lord.
Not your application in the will.
It's, my lord. Kindly bear with me for a moment. Page go to. I have annexed the application for grant, and there is a codicil. If your Lordship kindly take page 45 of the first codicil. Paragraph 2. Upon intestate death of my first wife, Kanta Babulal Verma, without any issue in 75, her right title and interest in Bastakor lands, etc., vested in me.
And second wife death certificate is there.
Second wife.
Death certificate is also not there.
No, death certificate is annexed below. Second wife death certificate is very much annexed below. I'll give you, Lordship, below. Page 60 below. Kindly see page 60, annexure F to the main application. Chandra B. Verma died on 4th August 2004.
Yes.
Page 60.
So what do you want?
I want dispensation so far as the death certificate of the first wife.
I will give the dispensation subject to prove the death of the in the solemn form.
Whatever comments to your Lordship.
Yes, because if the document is not there, then oral evidence has to be led for the to prove the evidence.
Your second wife has also died. He tried his best to have an issue, never got any.
But oral evidence.
Tremendous.
That's why I'm telling. Okay, death certificate is not there. 75. I am giving the liberty, but that has to be proved in the solemn form.
Very well. Meantime, my lord, may the citations be issued.
That can be done.
Yes.
Solemn form after
publications.
the all completion of our process.
Good.
So and so appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament of the testator Babu Lal Madhav G. Verma alias Babu Lal M. Verma. Counsel for the petitioner submit that the testator had initially married to one Srimati
Kanta Babulal Verma.
One Srimati Kanta Babulal Verma. Kanta Bai Babulal KNT page 37. Kanta Bai Babulal Verma. But she died on 1975 without any issue. And subsequently the testator has conducted second marriage. And this second wife also died without any issue. Full stop. Counsel for the petitioner submit that the first wife died in the year 1975, but the petitioner is not having any document with regard to the death of the first wife of the testator. The petitioner has made several endeavor, but he could not get the death certificate or any document in support of the death of the first wife of the testator. Accordingly, counsel for the petitioner press for leave to proceed with the PLA application without filing the death certificate of the first wife, namely Kanta Bai Babulal Verma. Full stop. The petitioner has also prayed for issuance of special citation, general citation, publication of the notice in the English daily newspaper and Bangla newspaper, which were circulated in Kolkata, as well as citation under section 283 within bracket 3 of the Indian Succession Act. Consider the submission made by the counsel for the petitioner. Petitioner is allowed to proceed with the PLA 476 of 2023 without filing the death certificate of the first wife of the testator, namely Kanta Bai Babulal Verma, subject to prove the death of the first wife in the solemn form. With regard to prayer
C, my lord.
C.
Prayer 1.
C. Within bracket I, and 4AL. 1, 2, 3, 4, 5. C, I,
Roman 4.
I, and I4 is allowed. Full stop. GA number 1 of 2025 dispose.
One humble request, my lord. May the department act expeditiously, because
you can't.
Kindly.
The department is directed to take appropriate steps.
Deeply frustrated.
Next.
I appear for the petitioner, my lord. This is my application for amendment, second amendment, my lord. Your lordship, by an order dated 27 January 2025, granted us leave to make this amendment application. My lord, in the main petition, the brother of the testator was already there, as in
Bringing
paragraph
the
7.
legal heirs of the deceased Biswanath law.
Yes. If your lordship kindly takes the second annexure, the annexure B is my proposed amendment. If your lordship kindly comes to page 3 of the proposed amendment. That's the petition proposed amendment. Page 3 of the proposed amendment. That's continuous page number 9.
Yes.
Paragraph 7, my lord. First is, number 1 is Vishwanath law. And my lord, he died after the death of the testator. Therefore, my lord, 5, 6, and 7 at page 4, the next page, they are the heirs of Vishwanath law. I just want to bring them on record. Because they have...
This is only...
No, so paragraph 8, there was a technical error, just a typographical error. There was a mistake in the date.
Consent affidavit.
Yes, ma'am. There's just a mistake in the date. It was there. And my lord, consequent to the first amendment, prayer A has to be amended because citation has to be served. Only these three.
So appearing for the petitioner. Petitioner has filed the present application being GA2 of 2025, praying for amendment in the probate application being PLA 212 of 2023, as appearing in proposed amendment page number 9, 10 and 11. Full stop. Consider the submission made by the counsel for the petitioner. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the application. Considering the above, prayer prayer 1I of the master summon is allowed. GA2 is disposed.
One more indulgence, my lord, on the last occasion, if your lordship sees the order, your lordship granted us leave to verify the petition by one executive, because the other executive is extremely ill. That leave be given.
The counsel for the petition submit that out of the two executors.
There are two executors, both are applicants.
One executor is old age and is bedridden, is not in position to affirm the affidavit. Accordingly, exemption is granted to the petitioner to re-verify and reaffirm the application after the amendment by one of the executor.
Grateful, my lord, that 96. Short.
Yes.
The only one amendment, first amendment, I'll just quickly indicate. I understand retaining a lordship back, my lord. Pursuant to the PLA being filed, my lord, we had taken out an application for breaking open a locker in a bank. That was a part of the assets. Once the locker was broken open pursuant to the order of a coordinate bench, my lord, the executor finds that there are a lot of valuables inside that locker. We want to amend the affidavit of assets only to bring them on record.
Where is the report of the inventory?
My lord, inventory is, my lord, page number 7 of my application. My lord, the
item inventory, you wanted to bring all the things.
These have been there. My proposed amendment is also on record, my lord.
Where is
starting at page number 11. Page number 12 onwards is relevant, my lord. We marked it by red ink. Paragraph 6, the valuation has changed. It's gone up from 80 lakhs to, my lord, 1 crore 14 lakhs 48,000. And paragraph 13, my lord, in serial number E, the valuation of that has also gone up. We had originally written not known.
So appearing for the petitioner. Police counsel for the petitioner submit that after filing of the probate application, the locker of the testator was open and inventory was made. After the inventory, it was found that several valuable items were found, and accordingly the petitioner intend to amend the affidavit of assets as per the inventory made after the opening of the locker. Consider the submission made by the counsel for the petitioner. This court find that the amendment as sought for by the petitioner is very much necessary for proper adjudication of the case and will not change the nature and character of the application. Accordingly, prayer A2 C of the application allowed. GA2 is disposed of.
My lord, item number 97, similar fact, only less valuable item is found in the locker. Only 100 rupees was found in the locker. That need to be added.
100 rupees you want to include?
The department is saying that you want to include as there is a report
100
of
rupees you want to include?
and that is given by the receiver in the report. That is the reason, my lord. Yeah.
Where is the amendment?
The amendment is in
This
page
one,
number 9.
page 21. That is only.
That is the only amendment. The figure subsequently changes.
For the petitioner, the petitioner has filed the present application being GA2 of 2025, praying for amendment in the affidavit of asset. Counsel for the petitioner submit that after opening of the locker of the testator, it was found that in the locker the
special
rupees,
officer.
100 rupees is in the locker, and amount of rupees 100 rupees was found. According the same is to brought on record in the affidavit of asset. Consider the submission made by the counsel for the petitioner. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character. Full stop. The prayer A and B of the master summon is allowed. GA2 is disposed.
My lord, only my lord, humble request, my lord. My lord, the new matters, my lord, may it retain the list, my lord, because my item number 100, my lord. New matters come in, my lord, my item to court.
No. I am maintaining the serial as it is. I am not taking. That's why I am not taking any mentioning matter. which is on the list, this will be continue as it is.
But my item number 100, what happens, the last time occasion, it goes, new matter comes, it goes down. Therefore,
Continue, if it added, it will be added.
Later on, kindly, grateful.
Item number 92, I have to say something, regarding there is a direction for FTP that has not been filed. If the matter is not taken up, your lordship was pleased to confirm a sale but the HEOT.
Okay, next time 82 I will read. 82 also, huh?
Item number 82.
82 is called. 82 is called. 82 is the civil, not the PL.
But kindly take up if the registration is done in the instance of the HET, then my application will be infructuous. That is the urgency because there is a direction.
Okay, let come on Wednesday, we'll see.
Wednesday.
Come Wednesday, because the
May I mention at Wednesday?
Wednesday you come see how far this court can go, then we'll see to
Yes, sir.
the day's list. It was not called on today in the first half, my lord, and I'm told at 3 p.m. your lordship will have appellate side today. The interim order which was passed by your lordship is due to expire today. So
37,
I have
38.
given notice to my other side. This is an application for judgment upon admission where ad interim order of injunction was passed by your lordship. I have given notice and this was the last order passed on 22nd, and on 7th of August 2024 the first order was passed allowing the ad interim order of injunction.
Only in one suit, 236.
Yes, there are two connected suits.
So injunction is only one.
No, injunction is passed in both. I am carrying the main preliminary order of one of the suits.
So and so appearing for the petitioner, plaintiff.
37 and
The
38.
plaintiff is mention the matter after notice to the other side. Though the matter is listed as item number 36 and 37.
No, 37 and 38.
37 and 38 of the day's list. But that same could not be taken up for hearing to according the counsel for the petition prays for submit that to the interim order granted earlier is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 26th of March 2025 or until further order, whichever is earlier. Let the matter
Grateful, Your Lordship. And may I be permitted to file the affidavit in reply? Copy has already been served.
keep with you.
Okay, grateful.
Both, huh? Yes, call the list.
Good to see.
Am I for the respond number 3, Malad?
Yes.
My lord, I had, my lord, address your lordship, my lord, on, my lord, really 3 issues yesterday. My lord, that, my lord, Mr. Ghosh, Mr. Sudhito, surname,
Sudeep
Bhattacharya and my lord, Mr. Tandon.
Pradeep Tandon.
My lord, Pradeep Tandon could not have been appointed as trustees, my lord, on 10th of February 2024. And therefore, my lord, also consequently, my lord, as members of the General Committee
Yes.
on 11th of February 2024. And my lord, I had also submitted, my lord, that the removal of the money, my lord, was bad. This is, my lord, as far as, my lord, the composition, my lord, of, my lord, the trust and, my lord, governing council, my lord, is, my lord, concerned. I had also, my lord, submitted to your lordship regarding, my lord, the conduct, my lord, of Harshvardhan Lodha. My lord, the statement, my lord, being asserted, my lord, that they came to know only when, my lord, which is not correct, my lord, 9th of December 2021, my lord, he, my lord, knew. Now I want to, yes. And my lord, this is, my lord, conduct is relevant, my lord, for discretionary relief. I'll come to the cases later. Now, my lord, even, my lord, as far as, my lord, Vishwajit Mathilal is concerned, my lord, I had submitted, my lord, by virtue of regulation 47, read with regulation 5, my lord, he, my lord, cannot continue as a director. The 3 consecutive meetings, my lord, I had shown your lordships. In fact, 6, my lord, consecutive meetings where he had, my lord, not, my lord, attended. Now, my lord, I come to even, my lord, regarding, my lord, the false case run by Matilal, my lord, with regard to knowledge. My lord, he says, my lord, he came to know on 2nd December 2021. Now, I want to show your lordship, my lord, that here also, my lord, that, my lord, a false case, my lord, has been made. And that, my lord, your lordship kindly takes. My lord, my lord, kindly take, my lord.
Case first. Para 10, page 6.
I forget that. Yeah, I'm on note 2. Come straight away. What has he said in the first case?
That he didn't receive it in April.
Yes, my lord, I want to show your lordship, my lord. My lord,
GA1 and
GA1
CS20.
in CS21, my lord, kindly see the case, my lord, which has been run.
GA1, CS21.
My lord, paragraph 10, kindly see.
Yes.
My lord, it starts, my lord, at my lord, page 5.
Yes.
Kindly see, my lord, sometime around April 2020, at the behest of the 3 joint administrators pendente lite, short 2 of the joint appointed in so-and-so testamentary suit for so-and-so, an attempt was made to take over control of the Board of Trustees Governing Council by purporting to remove respond number 6 as trustee, as well as being by purporting to appoint so-and-so, followed by 1 and 5 as trustee and members. It would be evident from the purported circular resolution dated 16th April that the said purported reconstitution of trustees and governing council is on the premise that the petitioner society is a part of the estate of PDB and consequently under the estate of so-and-so, 2 of the joint. The secretary of the plaintiffs is also a trustee and member, came to know of the purported circular resolution dated 16th April 2021 when he received 2 several notices to which several documents were enclosed, including the purported. This I've already shown as one of the notices, my lord, for a meeting which he did not attend. So his case is, my lord, only on, my lord, 2nd of December.
Yes.
Now I want to show your lordship, my lord. My lord, Matilal, my lord, writes, my lord, a letter, my lord, this is, my lord, dated 23rd of, dated, my lord, 23rd of December, my lord, at page 52 of GA1 in CS21. My lord, this is, my lord, the, my lord, letter, my lord, by our advocates in response to, my lord, his letter at page 49, which I had shown your lordships, my lord, 9th December 2021 letter.
Yes.
Now, my lord, I'm just showing, my lord, the response, my lord, to this. My lord, kindly come to, my lord, page 52, 3rd paragraph, my lord. My lord, kindly, just before that, the subject, your email dated 9 December 2021.
Page 54.
Page 52, my lord. I'm sorry, my lord. Yes. Page 52. This is in response to, my lord, 49.
Yes.
My lord, in fact, I should place 49 in this context also. I'm sorry, my lord. 49, 9 December, my lord, the communication of, my lord, Matilal to, my lord, Mr. Daga.
Yes.
My lord, 2nd paragraph, my lord. From a perusal of the subject notices, I found that a purported circular resolution of the society was allegedly passed on 16th April 2021. At the outset, I would like to state that I've never received any notice of such circular resolution dated 16th April 2021, and for the first time became aware of the purported circular resolution from the subject notice. That's 2nd December. Kindly see the subject notice, 2nd December. Further, the circular resolution enclosed with the notice sent to the trustees do not contain signatures of any of the trustees. Contents of the circular resolution as it is are incorrect and not based on facts. Please furnish me a copy of so-and-so as signed by the trustees. You are aware that there are 4 trustees of the society, namely Harshvardhan, Sushil Kumar Daga, Krishna Damani, and myself. I've also ascertained from Mr. Harshvardhan Lodha, one of the trustees and member of the governing council, has also confirmed of not receiving any of the aforesaid notices and the purported circular resolution. In any event, on the face of it, the circular resolution is illegal, null and void for the reasons stated here under. I've checked my records and I cannot recall having attended the meeting either of governing council or trustees held on so-and-so. Then, my lord, kindly take the 2nd paragraph. My lord, here also, my lord, like Harshvardhan Lodha, my lord, the case of, my lord, Matilal also is, kindly see, my lord, the 3rd line. You are also aware that all trustees, in terms of rules and regulations, are required to act jointly and unanimously, and any act done in violation of the same is illegal and a nullity. Then, my lord, further the society, my lord, kindly see, my lord, further the society is to, so my lord, first point I make, even his cases, everybody has to act. Here, my lord, everybody has not acted. Then, my lord, Further, the society is to act in terms of its own rules and regulations and not as per the direction or at the behest of any person or body of persons appointed over an estate, who have no right whatsoever in the society. Any act done, kindly mark this, my lord, any act done, so the act of the society, as per their direction or at their behest, would amount to intermeddling in the affairs of the society, which is illegal and prohibited in law. It is unthinkable and unheard of that a charitable society like ours would act under the instruction of or at the behest of third parties who have no right or interest whatsoever in respect of the society. The changes sought to be made in the mode of operation of bank accounts, electing members of governing council and reconstituting whose names have not even are inappropriate, improper. It further appears that many of the members of the project execution committee who are supposed to be involved in execution so and so have not attended any of the meetings, some of which have been shown to have been held on virtual. Please let me know whether absentee members were at all given notices. I'm not at all comfortable the manner of functioning, etc. Rectify the notice and fresh notice to be issued. So, my lord, I pause here. Two things are being said. My lord, that first, my lord, that he had not received, my lord, three things actually. 16th April, earlier he only got it on 2nd. Second thing which is being said is, my lord, they all have to act unanimously. And third, my lord, very importantly, that you have taken a decision at the behest of outsiders, which is the APL, who asked you to do something. So this decision of the society should not have been taken on the basis of behest of a stranger.
Correct.
My lord, that's, my lord, the case.
These are the things.
Important thing is that, my lord, he recognizes that 16th April 2021 is not an ipso facto vacation, but, my lord, a decision of the society. This is very important. On, my lord, a letter which was unauthorized.
Yes.
Now, my lord, kindly come to
Yes.
my lord, the lawyer's response, page 52. Kindly take, my lord, the third paragraph. The circular resolution of the trustees of the society dated 16th April 2021 were sent to you by speed post bearing receipt number so and so and received by you on or around 17th April. So, my lord, it's circulated. It reaches him on the 17th. Now, my lord. So, my lord, first thing is he got the circular resolution. This is what is being asserted. In fact, you had visited the office of our client soon thereafter and discussed with them about the said circular resolutions and the background of the matter. You have apparently decided to withhold your consent to the same. So, my lord, he was not agreeing. So, my lord, one assertion that you did receive 16th April. Second assertion, you had a discussion, my lord, with Daga Damani, who are the clients of my lord CLO, Chaudhary Law Offices. And, my lord, third thing is, what is being asserted is, you decided to withhold your consent. Therefore, you objected to the circular resolution. You have apparently decided, in view of the fact that you are employed with Birla Corporation under HV Lodha, it is surprising and shocking that you are now completely denying any awareness of circular resolutions received by you. You had also attended the previous meeting of trustees and members of so-and-so held, though now you are feigning lack of recollection of the same. Now, my lord, apropos this resolution, we also say, and I'll make that good, because in a removal case, my lord, all trustees don't have to act. So, my lord, it is stated, your statement that all trustees have to act jointly is incorrect. This is, my lord, the case we run. So, my lord, we have referred to this. Now, he's denied it later. I'm, my lord, not. Say, no, I did not. But, my lord, now kindly have a look, my lord, at, my lord, what we have produced by way of, my lord, evidence in this. My lord, kindly come to page 167, my lord, GA1 of CS16, volume 2. Volume 2, GA1 of CS16. My lord, kindly come to, my lord, page 167.
Yes.
My lord, 14th March 2022. My lord, the letter is addressed, my lord, to, my lord, the postal authorities.
Yes.
My lord, this is in reference to the above caption subject. We would request you to please share the delivery confirmation of so-and-so dated so-and-so, addressed to Sri B. Matilal Bobajar so-and-so. Durga Pathori Lane, Kolkata so-and-so. We had sought information about the delivery status of the said article, Namda so-and-so from Kolkata. We did a letter dated so-and-so, but the same was addressed to your office due to the administrative control by Deputy Director so-and-so. We did a letter. We therefore request you to kindly let us know the delivery status of the said article. And my lord, kindly see, my lord, this has happened, my lord, on 14 March 2022. And my lord, earlier inquiries, my lord, after receipt of his letter, my lord, are of 13 December at the bottom, my lord, enclosed, letter dated 13 December and 28 December. Now, my lord, I have enclosed those. Kindly come to, my lord, 28 December 168. 168, my lord, the enclosures. Disposal of Kolkata so-and-so, kindly herewith enclosed a copy of complaint so-and-so dated 13th December 2021. So, my lord, our complaint was regarding this. This is being forwarded, taking necessary and to reply directly upon intimation. And my lord, copy, my lord, is sent to Postmaster Bobazar, my lord, as well, and my lord, the South Point Education Society, which was, my lord, under our control. And 13 December, kindly have a look. That's the other letter. So, my lord, 13 December is when we make the inquiry. They respond, my lord, on the 28th of December, pursuant to which, my lord, we write, my lord, the letter to the concerned post office, my lord, on, my lord, 14th March 2022. And, my lord, we get, my lord, the response, which is at page 170. Kindly see, my lord. This is 24th, page 170, my lord. 24th March 2022. So, my lord, a letter, my lord, to, my lord, the South Point Education Society, Birla Building, 4th floor, so-and-so, dated Kolkata, the 24th March. Subject, non-delivery of so-and-so. Speak article, dated so-and-so, addressed to so-and-so, and sent by South Point Ed. Sir, madam, with reference to the subject mentioned above, it is to intimate that the article in question has been delivered to the addressee on 17th April from Bobayar Post Office. The concerned delivery slip is enclosed.
Yes.
Now, my lord, if that is the case, and my lord, here, my lord, I have, my lord, evidence from, my lord, an independent, my lord, party, my lord, who are responsible for seeing, my lord, post is, my lord, accepted, delivered, my lord, saying their records show that this has been delivered on the 17th of April. Now, my lord, if that is the case, and he has withheld his consent, that means he is opposed. Now, my lord, kindly come to why no notice to Harshvardhan. I say I didn't give notice of circular to Harshvardhan. My lord, I accept that, but why no notice? Now, my lord, kindly come to the regulations, page 58. My lord, kindly come straight away to, my lord, 5. At page 59. 58, it starts, my lord, the regulations.
Yes.
Of, my lord, this is CS 16, GA1.
Yes.
Now, my lord, kindly take 5. A member shall cease to be a member of the society if, my lord, kindly comes to, my lord, I, he acts prejudicially to the interest of the society and a resolution is passed by the society against him by a 2/3 majority. Now, my lord, this is, my lord, to be read with 47. Kindly come to, my lord, 47. At page, my lord, 69.
Anyway, yes.
A trustee shall vacate his office for the reasons for which a member of the society shall cease to be a member. So, my lord, what applies to members applies for trustees, and for removal, my lord, 2/3.
Yes.
Now, my lord,
The earlier clause was page 59.
Yes, page 59
Clause
at 60.
Yes.
My lord, 59 5I at page 60, my lord, he acts prejudicially to the interest of the society and a resolution. This is for members.
Yes.
But members, my lord, provisions are applicable to trustees.
Yes.
That's what 47 says.
Yes.
Which is at page 69.
Correct. Yes. Then.
So, my lord, now, my lord, the question is, my lord, there was, my lord, Daga, there was Damani, there was HVL, and, my lord, there was Matilal. Now, my lord, 2/3, my lord, here, my lord, is of what? My lord, HVL cannot vote. My lord, it concerns him. So, it's 2/3 of the remaining, which is why no notice to him.
Correct.
And, my lord, who are the three? My lord, Daga, Damani, Matilal. So, my lord, 2/3. So, my lord, Lodha, my lord, has been, my lord, removed. Valid removal as on that date, as per, my lord, the articles. Kindly, my lord, forget about, my lord, all these, my lord, orders, etc. for the time being, because it's a decision which has been taken. 16th April. Accepted, my lord, in their letters, accepted by Matilal also, that's a letter. You took a decision on the basis of someone who could not have interfered. Okay, I've relied on something irrelevant. Let us say, my lord, I've relied on something irrelevant, but the decision is mine. So if that decision according to you is bad, at least, my lord, on, my lord, the given date, my lord, which was, my lord, 9th of December 2021, my lord, Lodha had notice of it.
Yes.
Now, my lord, if Lodha has notice of it, my lord, that is, my lord, we have to look at now, my lord, why he hasn't challenged. Because the cases he cited, I'll deal with them, that I don't need to challenge it. Similarly, my lord, Matilal, who knew on 16th April, he has also not challenged. So today, before your lordships, my lord, while this matter is being argued, there is not even one challenge.
Yes.
My lord, which was, my lord, taken to, my lord, this resolution of 16th April 2021. Though Matilal was aware of it on 16th April 2021, and Lodha was clearly, by his own admission, aware of it, my lord, on 9th of December 2020. Now, my lord, this is, my lord, the conduct regarding notices. Now, my lord, I want to come to, my lord, their conduct regarding, my lord, notice to, my lord, Damani. Now, kindly see what they have said with regard to notice having been given, my lord, to Damani.
Yes.
My lord, kindly have a look, my lord, at the notice which they said we gave notice to Damani. Now, kindly come to page 487 in CS 21, volume 4. Volume 4.
Yes.
Now, my lord, kindly see, my lord, from, my lord, again, my lord, Vishwajit Matilal, who probably, my lord, in fact, wasn't even a trustee on that date.
Page 487.
487. Law, my lord, as per documents disclosed by him, he wasn't even a trustee.
Yes.
Now, could he be a member of, my lord, the General Committee or Governing Council? Complete stranger. My lord, anyway, we'll, my lord, for the sake of argument, my lord, take it as a notice, my lord, which was sent, my lord, kindly see the email. It's sent to Harsh Lodha, who, according to us, vacated, and, my lord, Damani. Notice and agenda of meeting of Board of Trustees. Please find attached notice and so of South Point to be held on 10th at 5:30 so. Kindly make it convenient to attend. And, my lord, the agenda, my lord, is the next page, etc. Now, my lord, kindly note one thing. On that date, Damani was in a correctional home. It's nobody's case that he had, my lord, his, my lord, access to, my lord, his email. Wouldn't have. There is, my lord, a procedure prescribed under the state's jail code to form, my lord, service, my lord, to inmates. Now, my lord, kindly take, my lord, the jail code. My lord, I've got the relevant.
Yes.
My lord, kindly take. My lord, the jail code should have been changed. My lord, in West Bengal, we've, my lord, you done away with the expression jail. We use it, my lord, as we say it's correctional home. But my lord, jail code remains as it is. It's not been said.
There
my lord.
also jail manual.
Jail manual. Because, my lord, we are, my lord, trying to go, my lord, towards, my lord, a regime of open, my lord, correctional homes and renaming, my lord, jails as correctional homes. Anyway, my lord, kindly come to, my lord, the extract I've given, my lord, special rules relating to under trial and civil prisoners. At page 206, my lord,
Yes.
at the top. Unconvicted criminal prisoners and civil prisoners shall be granted all reasonable facilities at proper times and under proper restrictions for interviewing or otherwise communicating either orally or in writing with their relatives, friends, and legal advisors. Then, my lord, 683. Every interview between an unconvicted prisoner and his legal advisor shall take place within sight, but out of hearing of a jail official. A similar concession may be allowed by the superintendent in the case of an interview with any near relative of the unconvicted prisoner. Kindly come to, my lord, page 202 at, my lord, 664. My lord, here the heading is general rules.
Yes. Six.
62. Sorry, my lord, 664. My lord, general rules start from 663. My lord, which applies to everybody. Then, my lord, kindly see, in addition to the privileges referred to in Rule 663, convicted prisoners in Division 1 or 2 may have interviews with their relatives and friends and write letters to them once a fortnight. And convicted prisoners in Division 2 may have interviews with their relatives and friends and write to them once a month. Then, my lord, 2 applies to all. Letters addressed to prisoners shall be made over to them as and when received, provided that on being censored, they are not found objectionable. So, my lord, there's a provision, my lord, for, my lord, service, which they, of course, conveniently forgot, my lord, and sent it by email knowing he's in. And that act, my lord, knowing that somebody is in jail, cannot have access to his email, is, my lord, mala fide. Now, my lord, this has been decided, my lord, by, my lord, the Supreme Court, my lord, in a case where, my lord, where notice is served, my lord, at a registered address. My lord, I have given, my lord, let us say I'm a trustee. I've said, please address all letters to me here. But, my lord, I happen, my lord, to be in, my lord, let us say, my lord, known to them, the, my lord, other trustees and, my lord, the officials, my lord, of, my lord, the society. My lord, I happen to be, let us say, in, my lord, Bangalore, Bengaluru. And, my lord, what happens is, my lord, they go and serve, my lord, a notice physically where I am, where the address that I've given.
Yes.
My lord, would that be a valid notice? Knowing that I'm in Bangalore.
It is not.
It is not. Supreme Court, my lord, has held that. My lord, it's a celebrated case, my lord, which, my lord, I lost spectacularly trying to defend the indefensible. My lord, that is, my lord, 2006, 7 Supreme Court cases, 613. My lord, paragraph 46. This is, my lord, Ruby General Hospital. My lord, Mr. Fali Nariman, my lord, let me in this matter. Kindly read, my lord, para 46. My lord, what had happened in that case, my lord, there were two, my lord, NRI directors in the company. My lord, I showed board notices, notices of board meetings to have given to them at their registered addresses mentioned in with the company. Registered addresses were in India. And I, who was a brother of one of the NRIs, knew that both were in the US. And my lord, I took decisions like increase the shareholding, gave myself some, my lord, so that my lord, my shareholding would go up in the company.
Taking into consideration notice served.
And saying notice has been served, it's valid. So my lord, I defended it and I failed. Kindly have a look now. CLB, para 46. CLB, my lord, is the company law board, has in minute detail discussed with regard to all the resolutions which we have already adverted to. No proper notice was served on appellant number 1, who's a major shareholder of the company, or on appellant number 2. If the board meeting had been convened without proper service of notice on the appellants by respondent number 2, then such board meeting cannot be said to be valid. Mr. Nariman, however, tried to explain various meetings and the subsequent confirmation by the next board meeting to show that once the resolution of the subsequent meeting has confirmed the resolution of earlier meeting, then those minutes stand confirmed irrespective of the fact that the appellants had been served or not. We shall highlight some of the instances. We would show that how a subtle attempt was made to show that several notices were given to major shareholders of the company at the local addresses in India, knowing fully well that both appellants are NRIs. The outstanding feature is that appellant number 2, Dr. Binod Prasad Sinha, has been shown as an NRI, but notice to him was sent at the address Post Office Hirapur, shown district Dhanbad, Bihar, and those notices has even been sent with very short interval. The meeting was convened on 13th, the notice was sent on 8th. Likewise, another meeting was held on so-and-so, and notice was sent on so-and-so. Apart from this, it was known to the respondent Sajal Dotto, who is the brother of appellant number 1, that's Kamal Dotto, that whenever his brother comes to Calcutta, he does not stay in his house, yet the notices were sent to Jodhpur Park, Calcutta. This shows lack of probity on the part of respondent number 2 to somehow or the other oust his brother from the majority shareholding. Similarly, on the basis of etc. etc. And my lord, on that basis, my lord, it was held that all this, my lord, is bad.
Yes.
My lord, kindly see Placitor me, be that as it may, when such an important decision was taken in the absence of the main promoter, so-and-so, to oust him from and to install, it is the grossest act of oppression, so-and-so. And my lord, here, everybody was aware that my lord Damani had been, my lord, put into, my lord, a correctional home.
Yes.
And the High Court, my lord, has also held, it was at the instance of Lodha, who had set up the de facto complainant. My lord, to, my lord, institute, my lord, this criminal proceeding. And he's in jail. And then you say, well, now that I have somebody in jail, maybe I can push through something by way of majority by masquerading as a trustee and also allowing Matilal to function as a trustee. This is how they've acted.
Yes.
So, my lord, in fact, my lord, Damani, my lord, kindly note this date, was, my lord, taken into custody, my lord, on the 8th. Notice is 9th. My lord, meeting is 10th. My lord, short intervals have also been noticed, my lord.
When is taken? 6th.
8th. My lord.
Yes.
My lord, 9th, my lord, arrested. 8th arrested. 9th, my lord, police custody. 9th, 5:30 p.m. Notice given for, my lord, meeting of the Board of Trustees. On 10th at ना notice का आचे तो है.
Notice that at 10th meet
5:30 p.m.
Yes.
In case he gets bail and suddenly appears.
Yes.
So, my lord, this is, my lord, the conduct, my lord, of, my lord, Yes. Now, my lord, removal, my lord, in the case of my lord Damani would have to, my lord, the fact that, my lord, he's been arrested or there is a criminal proceeding against him cannot, my lord, in law be a ground, my lord, for, my lord, his removal. My lord, kindly come to, my lord, 5 again at page 59. CS 16, GA 1, page 59. My lord, that's where the regulations are, my lord. So
CS 16.
Yes, CS 16, GA 1, page 59. The regulations.
Yes.
And my lord, your lordship, my lord, will recall, my lord, that their averment is he was removed at that meeting, but the resolutions which have been given, no mention.
That your point.
Yes. Now kindly come to my lord 5. My lord, kindly see, a member shall cease to be a member of the society if, kindly come to F.
Yes.
He is convicted by a court of any offense involving moral turpitude or infamous conduct. Now, my lord, so, my lord, unless this is there cannot be automatic removal. Now, my lord, I just want to rely on, my lord, one case, my lord, in this regard, which is, my lord, 2019, 14 Supreme Court cases. My lord, page 1. My lord, kindly come to, my lord. This is the closest, my lord, I could find to, my lord, a trust. It was a Waqf deed, my lord, which had a similar provision. Kindly come to paragraph 8, where the provision is, my lord. At page 9, 2019-14 SCC, page 1, at para 8, page 9.
Yes.
May I, my lord, just place this? The learned single bench also did not find any merit in the argument that the appellant has incurred disability on account of pending criminal cases against him in terms of clause 6 of the 1973 Waqf deed as amended on 26 June 1973. The learned single bench held that mere pendency of criminal proceedings cannot debar the appellant to be appointed as chief mutwali, as the disqualification as per clause 6.2 of the deed is conviction of an offence involving moral turpitude alone for disqualification. The relevant clause reads as under. In spite of the fact that a person has a right to be appointed as a mutwali under clause 4, the Majlis-e-Ayan shall have the authority by a special resolution to refuse to appoint such person as a mutwali, or in the event of such a person having already been appointed as a mutwali, to remove or suspend him from office if, kindly come to 2, he is dishonest, addicted to alcohol, gambling, or has been convicted of some crime involving moral turpitude. Now, my lord, kindly come to para 56. My lord, which is at page, my lord, 27.
Yes.
My lord, just 4 lines. The argument that the appellant is involved in criminal cases is again not relevant at this stage. The 1973 deed provided for disqualification of conviction in criminal case involving moral turpitude. None of the criminal prosecution launched against the appellant have ended up in conviction. Therefore, there is no disqualification attached to the appellant at this stage. So, by virtue of, my lord, only criminal proceedings, he could not be disqualified. No.
Yes.
No? Now, my lord, one other thing I just wanted to show your lordship. I didn't, my lord, the last, just for completeness sake, my lord, in my lord, which I should have pointed out, my lord, I've shown your lordship, my lord, the clause, my lord, kindly take 5J, under which I say Matilal, my lord, had seized. He, my lord, page 59 and 60, my lord.
60, yeah, J.
He fails to attend 3 consecutive meetings without prior notice
or
the reasons therefore being unacceptable. So, my lord, if he has given prior notice that he cannot attend, my lord, that meeting will not be counted against him. Then secondly, even if he gives prior notice, but my lord, the governing council feels that, my lord, the reasons are not good enough, my lord, then also, my lord,
Can be taken.
it can, my lord. So, my lord, here, my lord, I had shown your lordship, my lord, the replies. My lord, kindly take, my lord, the meeting of 9th December, my lord, which was convened at 3:30 p.m. I had shown, my lord, their email. My lord, kindly come to page 49. CS 21, my lord, this is at CS 21.
Page 29.
49, my lord.
Yes.
Now, my lord, this is, my lord, given, my lord,
That is the
before, my lord, the time of the meeting. Meeting was at 3:30. So he's given a letter on the same day at 1:43. Question is whether, my lord, this is, my lord, prior notice, my lord, in terms of, my lord.
5J.
Yes. Now, my lord, with the prior notice has to say that he is not attending. My lord, your lordship will search in vain. My lord, this talks about everything, but, my lord, that he is not attending is not mentioned, that I will not attend. Similarly, my lord.
Dispense with the absences not there.
Yes, please, my lord, usually leave of absence.
Correct.
Second, my lord, they might say, oh, well, I cannot, I'm not going to attend. Even if he's not asked for leave of absence, my lord, it says, my lord, I'm not going to attend. Absent. Similar case, my lord, with
9th May 2020.
9th May, my lord, I had shown, my lord, all these, my lord, for each of the meetings. 9th May, my lord, there was another meeting of the trustees on 9th of May 2022.
Yes.
My lord, the meeting, my lord, was, my lord, at 4:30, and, my lord, email is of 2:17 p.m. My lord, barely 2 hours before. My lord, which is at page 78. Yes. My lord, again, my lord, nowhere does it mention that I will not attend. Then, my lord, comes, my lord, the next meeting of 20th May 2022. My lord, convening, my lord, by 11th May, my lord, convening on, my lord, 20th May.
Page.
That is, my lord, the notice I've shown, page 81, my lord, of GA1 of CS 21. Kindly see, my lord, their email. My lord, their email, my lord, is not a prior notice because the meeting date is 20th May. Their objection, my lord, whatever they write, they don't say is 15 June, page 88. Page 88 is 15 June. Kindly see, my lord, the date, second line. Matilal writing 15 June. And the meeting date, my lord, is 20th May. Lordship will find that at that page, subject notice dated 11th May, yes, convening meeting on 20th. So, my lord, this is not even prior notice. My lord, other cases had prior notice but did not say I will not attend. Third one, my lord, is, my lord, even after, my lord, the meeting date. Then comes, my lord, the fourth, my lord, which is of the meeting, my lord, is, my lord, of 23rd September 2022. My lord, here, my lord, meeting was at 11:30, 9:57 a.m. My lord, about, my lord, 1.5 hours before. My lord, they write page 112.
Yes.
Here again, my lord does not say he will not attend.
Yes.
Then, my lord, 11th September, my lord, is, my lord, the next meeting, my lord, which is convened at, my lord, 2:30 p.m. And, my lord, he responds to that on 11 September 2023 at, my lord, 11:01 a.m., my lord.
Page.
This is page, my lord, 103 to 1. My lord, this is 103 to 106 of CS16. CS16. GA1 of CS16.
Yes.
Here again, my lord doesn't say he will not attend. He challenges notice. He said, I'm forwarding notice to HV Lodha. You issue another notice, issue it to HV Lodha. But he, in fact, is serving HV Lodha.
Yes.
In fact, my lord, we wanted him to attend. My lord, kindly see, my lord, page 92 of CS21, GA, my lord, of GA1, CS21, my lord, page, my lord, 92. 29 June 2022.
Yes. Yes.
We always wanted him to attend. But, my lord, if he, my lord, colludes with, my lord, HV Lodha, my lord, all points available in law, my lord, I'm going to be taking against him. Last, page 93, 94.
Yes.
This is before the third meeting, my lord, where I requested him to attend. My lord, kindly see 94, to attend meeting of trustees as and when convened. You are called upon to withdraw baseless allegation, not to act prejudicial, attend next meeting. My lord, if he didn't want to attend, he should then say so, I will not attend. He said, no, notice bad. I'm forwarding it to HV Lodha. Withdraw notice, give another one. But he doesn't say, my lord, that he cannot attend or will not attend, my lord, that meeting. Now, my lord.
How much time will take, Mr.
My lord, I'll take some time because now I'll go to the orders. My lord, today is till 2:45, I'm told. So, my lord, tomorrow it's there. I'll be back.
Sense offering for the plaintiff, sense offering for the defendant, note collected. The counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. The matter is already fixed tomorrow at 2 p.m. This is the matter tomorrow at 2 p.m.
Obliged.
Please, Your Lordship. My Lord, I appear for the plaintiff in this matter. Your Lordship just fixed this for witness examination today.
Witness present?
Yes, my Lord.
How much time will take?
My Lord, I'll take somewhere between 15 to 20 minutes, although I've
bring.
Yes. I've proved each and every document by way of an affidavit, my Lord.
Please.
So it should not take a lot of time. I'll try to be as brief as possible.
Bring the witness,
Affidavit of competence.
Where is the witness?
And give me the judge's brief documents. My Lords, this is my original affidavit of evidence, the affidavit of competence, and the judge's brief of documents. My Lords, also, I take leave, my Lords, to file my affidavit under section 63 BSA. Although it is ready, I understand there is some minor infirmity, so I'll file it in the due course of the day, my Lords, if your Lordship kindly gives me leave for that. I'm so grateful, my Lord.
আমি
শপথপূর্বক বলছি
শপথপূর্বক বলছি এই মামলায় যা কিছু বলবো সত্য বলবো, সত্য ছাড়া মিথ্যা বলবো না,
কিছু গোপন করব না।
কোনো কিছু গোপন করব না।
আপনার নাম বলুন।
বিদ্যুৎ চন্দ্র সেন।
চন্দ্র
সেন।
বাবার নাম?
সুধীর চন্দ্র সেন, লেট সুধীর চন্দ্র সেন।
আপনার বয়স কত?
61।
আপনি কি করেন?
আমি প্রাইভেট কোম্পানি জলনিধি ভিটামিন স্পেশালিটিস প্রাইভেট লিমিটেডের
প্রাইভেট কোম্পানিতে কাজ করতে
একটা কাজ করি।
আপনার অ্যাড্রেস বলুন।
38 অরুণাচল, পোস্ট অফিস রহড়া।
38
অরুণাচল, পোস্ট অফিস রহড়া, পুলিশ স্টেশন খর্দা, 24 পরগনাস নর্থ, পিন নাম্বার 7000118
এক্সামিনেশন চিফ
118.
just বলবেন।
Yes. May I kindly show the original affidavit?
No.
I'm sorry to interrupt, madam. What is this document?
এই ডকুমেন্টটা কি?
এই ডকুমেন্টটা হচ্ছে এফিডেভিট অফ মাই এভিডেন্স।
এফিডেভিট অফ মাই
এভিডেন্স।
Who has prepared this document?
কে তৈরি করেছে?
This is prepared by Advocate K.S. Kakrania on instruction by me.
Are the contents of this affidavit true and correct?
Yes.
Can you identify the signatures appearing at the said document?
Yes.
Who has signed this document?
I have signed this document before both commissioners.
Oh. Where have you signed this document?
Not necessary.
Not necessary, my lord. I'm so grateful.
Next.
Yes. My lord, may I just tender this as evidence, the affidavit itself, because I have proved all the documents in this affidavit. However, I'll quickly show the original copy
Yeah, show the
and get it.
original and it will get
Very well. I'm so grateful, my lord. What is your position in the plaintiff company?
You're the
Manager Finance.
manager finance.
Since when have you been under the employment of the plaintiff company?
মানে
আপনি কবে থেকে ওই
99 থেকে।
Who has authorized you to file this affidavit in the present proceeding?
আপনাকে কে অথরাইজ করেছে এই অ্যাফিডেভিটটা ফাইল করার জন্য এই মামলা?
হ্যাঁ, আমাকে অথরাইজ করেছে ডাইরেক্টর অফ প্ল্যান্টিভ কোম্পানি সঞ্জয় কুমার ডালমিয়া।
Have been authorized by the director of the plaintiff company,
Sanjay Kumar Dalmia, director of plaintiff company.
Shown document dated 7th February 2025. These my lords, I'm tendering the original copy. I'm showing.
Page number?
This is page number 1 of the judge's brief, my lord. As reflected at page 1 of the judge's brief. What is this document?
Board resolution of the plaintiff company.
What does this document enumerate?
What?
এই ডকুমেন্ট দ্বারা কি বোঝাচ্ছে?
রিপ্রেজেন্ট করেছে বিদ্যুৎ সেনকে ইয়ে করার জন্য, রিপ্রেজেন্ট করার জন্য দিয়েছে।
I have been represented.
This document provides me to represent the plaintiff company in the court proceeding.
What is the date of this document?
7th February 2025.
Who has signed this document?
Director of the company. Director Sanjay Kumar Dalmia of the company.
How did you come in possession of this document?
আপনি কিভাবে পেলেন এটা? হাতে হাতে পেয়েছেন? কিভাবে পেয়েছেন?
এটা হাতেই পেয়েছি আমি, অফিস থেকে না আছে। হ্যাঁ।
I have been given this document in the office by hand.
Are the contents of this document true and correct?
Yes.
Lord, may I kindly tender this as
Exhibit A.
As although I've done it as 1, 2, 3 in my judge's brief, my lord, your lordship will kindly excuse me.
That's why.
Usually we do it as ABC in the lower courts. That's why. 1, 2, 3. My lord.
Next.
Yes. Shown document dated 13th February 2020. What is this document?
Memorandum of Understanding on 13th February 2020.
Page number?
This is 1A, my lord. Page number 1.
Shown page A of PD of the judge's brief document. Page 1A of the judge's brief document. This is?
This is Memorandum of Understanding on 30th February 2020. Dated 13th February 2020.
Between whom has this memorandum of understanding been executed?
Between Adcon India Limited and Jalniti Bitumen Specialties Private Limited.
What does this memorandum of understanding enumerate?
Understanding করছে
What does this memorandum of understanding enumerate?
আমি বলছি এটা এখানে একটা মেশিন স্লারি মেশিন নেওয়া হয়েছিল যেটা রোড কনস্ট্রাকশন ওয়ার্কের কাজের জন্য সেই এগ্রিমেন্ট হয়েছিল সেখানে
A slurry machine had been নেওয়া হয়েছিল purchase
না হায়ার পারচেজ করা হয়েছিল
had been hire purchased and regarding that
rented, that is.
Regarding that slurry machine, this memorandum of understanding had been signed.
Signed, huh?
Shown page 3 of the judge's brief document. Who has signed this memorandum of understanding?
The memorandum of understanding was signed by Vishal Agarwal, manager of Jalniti Bitumen Plaintiff Company, Jalniti Bitumen Specialty Private Limited, and Girish Kumar Kharbanda for Earthcon India Limited.
Has this document been executed in your presence?
Yes.
Where has this document been executed?
This document has been executed at Notary Public Office, City Code.
What was the purpose of entering into a memorandum of understanding with Adcon India Limited for the purpose of the said machine?
ওই মেশিনের সাথে যে মানে এই মেমোরান্ডাম কেন সই করতে হবে ওই মেশিনের জন্য
হ্যাঁ এই উদ্দেশ্য ছিল যে ডিফেন্ডেন্ট যে ছিল তার এই মেশিনের প্রয়োজন ছিল যেহেতু এটা
purpose was that the defendant was in need of
অর্ডার করেছিল একটা মেশিনের জন্য
machine and he had ordered a machine
for slurry work on road construction work by PWD department.
Road construction work by the
Harpal Singh, the defendant.
PWD work.
On PWD work.
How are you in possession of this document?
কিভাবে পেলেন এই ডকুমেন্টটা?
এই ডকুমেন্টটা দুটো তৈরি করা হয়েছিল।
Two documents were prepared.
একটা ডিপেন্ডেন্টের জন্য একটা প্ল্যান্টিভের জন্য।
For the dependent and another for the plaintiff.
এই প্ল্যান্টিভের ডিপেন্ডেন্টটা আমি অফিস থেকে সঞ্জয় ডালমিয়া ডাইরেক্টরের পারমিশন নিয়ে আসা হয়েছে।
This document of the plaintiff was brought by me on with the permission of the
Sanjay Kumar Dalmia, director of the plaintiff.
Director Sanjay Kumar Dalmia from the office.
Yes, next.
May this be tendered as evidence. Are the contents of this true and correct? I'm sorry.
Yes.
May this be tendered as evidence and marked B.
Exhibit B. Next.
Shown pages 4 to 7 of the judge's brief of document.
Shown page 4 to 7 of the JBD. Yes.
What is this document?
Test certificate of material supplied to dependent bitumen emulsion. This is the material called bitumen emulsion.
Who has issued this document?
Omega Consultant Services issued.
At whose instance has Omega Consultant Services issued this document?
Defendant request. At the request of the defendant, Harpal Singh.
Defendant Harpal Singh.
The test results of the goods have been supplied by which entity?
টেস্ট রেজাল্ট যে সাপ্লাই করেছিল কোন কোম্পানি করেছিল কে?
টেস্ট রেজাল্ট করেছিল তো ওমেগা কনসালটেন্ট সার্ভিসেস।
ওমেগা কনসালটেন্ট সার্ভিসেস।
The goods of which Omega Consultant Services, just strike it, I will rephrase it. The goods that have been tested by Omega Consultant Services, who had supplied the said goods to the defendant?
Jointly the between supplied the who has supplied?
Who has produced the materials before the Omega?
ওমেগা কে ওই টেস্ট করার জন্য কে ম্যাটেরিয়াল গুলো দিয়েছে?
ওমেগা কে টেস্ট করার জন্য দিয়েছিল ডিফেন্ডেন্ট দিয়েছিল।
ডিফেন্ডেন্ট।
Have these goods, being the subject matter of tests being carried out, been supplied by plaintiff to the defendant?
এই যে ম্যাটেরিয়ালটা দেওয়া হয়েছিল সেটা কি প্লেন্টিফ ডিফেন্ডেন্ট কে দিয়েছিল?
হ্যাঁ, প্লেন্টি মেটেরিয়াল সাপ্লাই করেছিল ডিপেন্ডেন্টকে।
Plaintiff had supplied the material to the defendant.
How have you obtained a copy of the said test results?
হ্যাঁ, এটা আমি ডিপেন্ডেন্টের অফিস থেকে অরিজিনাল ডকুমেন্ট থেকেও আমার রিকোয়েস্টেও অরিজিনাল ডকুমেন্টটাকে ফটোকপি করে আমাকে দিয়ে দেয় ডিপেন্ডেন্টের সামনে।
On my request, this document had been supplied by the defendant after photocopying it from the original.
Yes.
Yes.
Where have the documents been photocopied from?
Not necessary.
Not
Yes,
necessary.
next.
Okay, very good. What does this document enumerate?
Already stated.
No,
Test report.
What the
Already stated the test
Wait, wait.
report.
I'll wait. Are the contents of this document proven correct?
Yes.
This may kindly be
Exhibit C.
tendered.
Next.
Yes. Shown pages 8 to 225 of the judge's brief of document. Continue. এটাও যাবে last. What are these documents?
Invoices যেগুলো মেটেরিয়াল সাপ্লাই করা হয়েছিল ডিপেন্ডেন্টকে
Invoices of the materials that were supplied to the defendant
with e-way bill.
with
E-way bill.
e-way bill. E-way bill.
Do these documents also contain the credit and debit notes
Yes.
raised by the plaintiff upon the defendant?
Yes.
How many invoices have been raised by the plaintiff upon the defendant?
81 invoices.
Can you please, hello, these are 81 invoices. May I individually go through all? Not
Not
required.
necessary.
Who has signed these invoices on behalf of the plaintiff?
অ্যাকচুয়ালি সাইন করেছিল এখানে আমাদের কয়েকজন রিপ্রেজেন্টেটিভ আছে যারা ইনভয়েসে সাইন করে তার মধ্যে
There are few of our representatives who had signed these invoices,
namely Director Sanjay Kumar Dalmia of the plaintiff, CEO MG Dalmia of the plaintiff,
Yes, yes.
Logistic Manager Anup Saha of the plaintiff, Assistant Logistic Manager Bijay Sheth of this plaintiff, and Dipankar Dotto, accountant of this plaintiff.
Have these invoices been issued in your presence?
Yes. Yes.
Where have these invoices been issued from?
আমাদের কোম্পানি 130 কটন স্ট্রিট থেকে।
from our company
130 কটন স্ট্রিট রেজিস্টার্ড অফিস।
30 Cotton Street, registered office.
How are you in possession of these invoices?
এটা বুকস অফ রেকর্ডস থেকে আমাদের অফিসের বুকস অফ রেকর্ডস থেকে পারমিশন অফ দ্য ডাইরেক্টর সঞ্জয় কুমার ডালমিয়া অফ দ্য প্ল্যান্টিভের কাছ থেকে নিয়ে আসা
With
হয়েছে।
the permission of our director Sanjay Kumar Dalmia, I have got these documents from the books of records of our company.
Are the contents of these invoices true and correct?
Yes.
Who has issued the e-way bills on behalf of the plaintiff?
Signed. E-mail to sign করার কোনো কোশ্চেনই নেই because we are related. ইস্যু করেছে তো এটা ইস্যু করেছে জিএসটি পোর্টাল থেকে ইস্যু করা হয়েছে গভর্নমেন্ট
How you obtain the e-way bill?
How have you obtained these e-way bills?
মানে কি করে পেয়েছে এই হ্যাঁ এই গুলো পাওয়া গেছে হচ্ছে গভর্নমেন্ট পোর্টালে আমাদের রেজিস্টার করা আছে সেই গভর্নমেন্ট পোর্টালে রেজিস্টার থেকে আমরা ওখানে ডাউনলোড করে তারপর প্রিন্ট আউট করে সেই প্রিন্ট আউটটা রেকর্ডসের সঙ্গে মিলিয়ে তারপর দেওয়া হয়েছে এখানে
On a lighter vein, I understand your lordship also is now understanding some Bengali, the way your lordship is nodding.
Downloaded this e-way bill from the government registered portal and then taken a printout from our computer, and thereafter we compared the e-way bill with the
original records from our.
Have these e-way bills been obtained in your presence at the registered office of the company?
Yes.
Are the contents of these e-way bills true and correct?
Yes.
Who has issued the credit notes?
Plaintiff has issued the credit notes to dependent.
Can you please identify the credit notes that have been issued by the plaintiff company?
Can you identify the credit note issued by the plaintiff?
Judge's brief of documents.
Yes. Next.
No, he just has to identify it so that
Yes,
I can
it
ask
has-
a few questions.
Yes.
You're not given to him. What is in his hand?
Those are the original copies. If he wants, he can do it from the original copy.
Yes, original. But
this
you
is
need to
original.
identify from the original.
This is original.
Yes,
fine.
yes, yes.
Yes.
Who has issued?
Who has issued these credit?
Plaintiff has issued this credit notes. Credit note number 17 dated 13th July 2020.
Who has signed these credit notes on behalf
Signed. This is the 3 credit notes has signed accountant Dipankar Datta of the plaintiff. Signed by accountant Dipankar Datta, and 2 credit notes has signed by director Sanjay Kumar Dalmia of the plaintiff. Date 18th August 2021 and 30th August 2021.
Why have these credit notes been issued by the plaintiff company?
For rate difference of the machine. যেটা মেশিন আমরা হরপাল সিংকে যেটা মেশিন রেন্টেড দেওয়া হয়েছিল কারণ ও একটা
of the machine that was supplied to Mr. Harpal Singh
অন দ্য মানে তার রোড কনস্ট্রাকশন ওয়ার্কের জন্য যে মেশিনটা দেওয়া হয়েছিল
road construction work.
সেই রোড কনস্ট্রাকশন ওয়ার্কে উনি বলেছিলেন যে রেটটা একটু বেশি হয়ে গেছে রেটটাকে আবার ডিফেন্স করার জন্য দ্যাট ইজ ক্রেডিট নোট ইস্যু করা হয়েছিল
He had said the rates were higher and requested to lower the rates, therefore the credit notes were issued.
How are you in possession of the said credit notes?
ক্রেডিট নোটটা আমার কোম্পানি থেকে সরি আমার প্লেন্টিভের অফিস থেকে বুকস অফ অ্যাকাউন্টস থেকে ইন দ্য প্রেজেন্স অফ সঞ্জয় কুমার ডালমিয়া ডাইরেক্টর প্রেজেন্সে এগুলো পাওয়া গেছে
Received the
How many
credit
documents are there further?
from
There
the
are
books of accounts of the
Further
plaintiff
documents are
6
there.
more documents are there. I'll just very quickly go.
of
Next,
the
come on the
director
next.
Sanjay Kumar Dalmia.
Are the contents of these credit notes true and correct?
Yes.
Can you please identify the debit note that
Yes.
has been raised by the plaintiff?
There is only one debit note. This is debit note number 87 on dated 24th February 2021.
Who has issued this debit note?
Plaintiff has issued the debit note.
Upon whom has this debit note been issued?
Defendant.
What is the purpose of issuing such debit note by the
For
plaintiff?
TCS purpose. TCS.
How are you in possession of this document?
আমি এটা পেয়েছি বুকস অফ রেকর্ডস থেকে ইন দ্য প্রেজেন্স অফ ডাইরেক্টর দ্য প্ল্যান্টিভ সঞ্জয় কুমার ডালমিয়া
From the books of accounts of the company with the permission of our director Sanjay Kumar.
Who has signed?
Kumar Dalmia. Yes, sir.
Who has signed the said debit note on behalf of the plaintiff?
Accountant Deepankar Datta of the plaintiff. Deepankar Datta of the plaintiff.
Are the contents of the said debit note true and correct?
Yes.
Plus, all these documents may be collectively marked as Exhibit D.
D collectively. Huh?
Ledger. Oh. Next.
So appearing for the plaintiff. Plaintiff witness is present. During the examination of the plaintiff, documents were marked as Exhibit A to
D.
Exhibit
D, my lord.
D. Exhibit D. Due to paucity of time, examination chief of the plaintiff witness could not be completed. Accordingly, examination chief is deferred. Case is adjourned. List the matter. Give the date. 21st of April at 3 p.m.
I'm so grateful, my lord.
Further evidence.
Just your lordship will record that we've taken leave to file a section 63B.
The police the plaintiff has filed the judge's brief document, affidavit of evidence, and
affidavit of
affidavit 63.
Affidavit of competence has been filed. 63A has yet to come in.
Not filed. You file, huh?
Oh.
You file in the department.
Oh, very well, very. This 63A has.
Affidavit of evidence. Let the same be kept with the record.
I'm so grateful.
Milord, before calling the appellate side list, Milord, may I have your lordship's kind? May I have your lordship's kind attention, Milord? Item number 44 in today's list, Milord. We have filed one application for interim order, Milord. Milord, let the matter be fixed, Milord.
Saturday 10:11:45. Ready? Come. Or further, Sunday 12 o'clock. Since morning you are not hearing from this court. This court not having time till second week of April for upgradation of any matter. Then what can be done? If you want urgent matter, Saturday, Sunday, court is free. Next. Yes, appellate side.
Lordship will be taking up mentioning. Lordship will be taking up mentioning of the original side after this.
What?
Lordship for extension of interim.
All over. You missed the bus. 11:20. Kindly see the cause list.
I was under the impression it is at the time of rising.
That's correct. Okay, I will take.
After this, very well.
Already heard. If any matter is there, I will take that.
May I be permitted to mention one matter?
Yes, sir.
Two matter for upgradation.
Arbitration.
Upgradation.
Upgradation of
Item number কত বলা?
appellate side.
But appellate side.
Criminal revision.
139 and 140.
Criminal revision.
Yes, criminal.
139.
Yes, 139 and 140.
What is the urgency, sir?
The urgency is well in connection with a maintenance case. Execution case has been filed. 5,67,000 was due, my lord. But they are the landed court below directed to pay the entire amount at a time. But that I have challenged, my lord.
For the husband.
Yes, I am the husband. I am paying some installment.
You're not paid.
But some money has been paid. That was the due was my lord 5,67,000.
Correct. What was the monthly amount?
Monthly amount কত? Huh? No.
Monthly maintenance. What is the monthly maintenance?
7,000 per month.
7,000 per month and since which year you are not paying? Then it is the date of order. Which year the case was filed?
Well, case was filed, but here 24. Here revision is 24.
No, the main application.
But 17.
Then you drag the matter.
But we shall pay. We will definitely pay. But we want some installment, my lord.
Item number?
139 and 140.
So appearing for the petitioner. Counsel for the petitioner. Prays for upgradation of the matter. Accordingly, counsel for the petitioner submitted there is some urgency and accordingly prays for upgradation of the matter. In view of the submission made by the counsel for the petitioner, let the matter appear
on next Thursday. क्या date है? On 6th of March. 6th of March as at the top.
In the meantime, may I have the copy, my lord?
Yeah. In the meantime, the petition is directed to inform the next date of hearing to the opposite party.
As you know, I'm grateful to you. 6th March.
Yes. Next, call the matter.
I'm grateful.
Right for the LH container.
I'm appealing on
Appeal
behalf
is-
of
What
the
has happened?
petitioner.
Appeal pending?
The
Yet
appeal is
to be
still pending,
heard
Your
out,
Lordship.
my lord.
It will be listed, I believe, on the next week. So kindly keep it up to 1 month, Your Lordship. It might be done within that period of time.
Appeal appellate side. So-and-so appearing for the petitioner, so-and-so appearing for the alleged contemners. It is submitted that still the appeal prepared by the contemners are pending. In view of the above, the case is adjourned. Let the matter appear on 3rd April 2020.
My lord. We are grateful.
Deeply obliged.
Yes, next.
In item number 7, my lord, I beg to appear for the opposite party wife. In the proceeding under 125.
On this one?
Yes.
Yes.
In
You are appearing for?
the opposite party wife.
My lord, I'm for the petitioner led by Mr. Lahiri, my lord.
Huh?
I'm for the petitioner, my lord, led by Mr. Lahiri.
Yes. Yes.
Oh, we have to go there. That's it. Already get This is the proceeding under 125, my lord. A final order of maintenance has been passed in favor of the wife and the minor son. Minor son is about 12 years old now. 8,000 and 8,000 for the wife and 7,000 for the minor son. This quantum that has been challenged, this has been assailed by my learned friend in the revisional application, my lord.
Yes. On last day, I have done the matter. But I can do the matter. I have no issues on this. But only one thing that today there is a resolution probably at
3:30.
3:30.
It
But
will not be completed today.
it will not be completed, Milat.
Come next week.
Malat.
Monday. Tomorrow I have.
But I am taking only on Thursday, once in a week. This court is not heavy.
Very good. Very good.
As per the prayer, so-and-so appearing for the petitioner, so-and-so appearing for the opposite party. As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 6th of March.
Deeply.
This is an application for quashing of the proceeding.
Ah.
The other day, LLC directed me to cancel the Bengali complaint. So I have to do that, but I could not affirm because the client, but I have to do that.
So you are not affirmed, how you will file? You are not affirmed. So how you file in the court?
No, LLC can see this, I have cancelled that. That is it. For the purpose of cancellation, my lord, LLC kindly see the complaint. LLC go through, I will make my submission.
Yes.
Now, it has been alleged that for the purpose of taking loan, he was 15 lakhs was given on different days in the year.
Who are you?
I am for the accused, my lord.
You are for the accused. How many accused persons?
My lord, here in the total, my lord, I am come for 4%. Chief.
Total 4 persons have been named accused in the FIR.
6.
Total 6.
Yes, I have.
And 4 have filed this application.
Yes, yes, yes.
Yes. Then what is the section?
My lord, 406, 420.
What is the allegation? You
The
obtained
allegation taken money.
You have taken
Thereafter-
loan.
Yes, I have taken the money, but there is a lodged complaint was lodged in the year 2020 against one person. He has that I have not filed here. But that person taken money thereafter 3 lakhs out of 15 lakhs, 3 lakhs have been given. It will appear from the complaint itself. The first name is Alok Kumar Bera. The complaint was lodged in the year In the money was taken in the year 2019. Complaint was lodged before the police station against Alok Kumar Bera, the accused number 1. Thereafter settlement. No FIR was lodged, that I don't know, but at the intervention of the police, it is admitted in the complaint that 3,75,000 has been given. This 2020. Thereafter 2023, in the month of August, complaint has been lodged for the real rest money 11,25,000. But it is purely evil, assuming for the sake of argument that money was given. It is first of all that he already lost the complaint in the year 2020 for the against Alok Bera, not the present petitioner. So, evil assuming that the money was taken, that was taken by the Alok Bera, and that has been settlement was made. 3,25,000 has been given, 75,000, and rest for the rest 11,25,000 he has lost this complaint. So how this complaint is maintainable? Dispute if any yearly
When the complaint was lodged?
Well, complaint was lodged 31st August 2023.
31st of August 2023.
Yes, ma'am.
So what is the stage of the investigation now?
So it's a complaint case, ma'am.
Complaint case?
Yes, ma'am.
Where is the cognizance?
Well,
The magistrate has taken the cognizance.
Yes, my lord.
Where is the cognizance order?
Well, summons has been issued. I kindly see the
Summons might be issued. The court has to see. This is the warrant tribal case.
well, kindly see before the complaint. I have received the notice of which the victim for the summon.
Correct. It is someone I am not. This court is not denying. Where is the order of taking cognizance? Where is the evidence of the witness on essay? The court might have been taken the evidence of the witness on essay and satisfied with the record. Then the cognizance was taken. Then the summon was issued.
Then I have to produce the essay and the order sheet.
Yes. And what document they have relied upon?
That is true, my lord. Only for causing criminal. No, the complaint
Caution.
case.
If
the
it is
essay,
a
complaint,
state
essay
case, if it is state case, you can come with the charge sheet or FIR. The court can call the CD. It is the CR case, complaint case, lodged by the complainant.
Yes.
You are the accused. The complaint case, there are procedure. Complaint case has to be filed. If it is summoned tribal case, essay, issue notice, you appeared, get the bail. If it is a warrant tribal case, essay, cognizance, then you have to change. Then what are the materials on record before the magistrate before taking the cognizance? The court has to see
I have
this.
to annex the essay and the order sheet. On which the
Complaint.
Complaint. Complaint I
Complaint.
have annexed.
Complaint. Thereafter the order sheets where the cognizance has been taken and the
And the
document they are relied upon. There are complaint case.
That is
List of
essay.
documents and list of witnesses might be there.
Oh, that is there. List of evidence.
List
That
of
is there in
evidence
the
and list of document.
documents.
Without the document, how the court can taken the cognizance, sir?
I will make the supplementary affidavit and file all these documents.
Sons appearing for the petitioner. Counsel for the petitioner. Submit that, though the translated copy. He has made the translated, but the affidavit has not been affirmed. Counsel for the petitioner further submit that he has not enclosed the documents relied by the complainant along with the complaint and order sheets of the London magistrate as well as the order taking cognizance by the magistrate wherein the summons has been issued upon the accused person. Counsel for the petitioner prays for time to file supplementary affidavit disclosing all the documents. Consider the submission made by the counsel for the petitioner. Is time to file supplement and the petitioner directed to file supplementary affidavit within 2 weeks. Please the matter on 13th of March 2025. Next.
My lord, I am appearing for item number 9 and 10 and led by Sir Shomi Ganguly. I'm praying for not this week, my lord.
Yes.
I'm praying for not with these things.
Petitioner director issue notice upon the opposite party in file. Where is the notice?
Yes, sir.
Where is the affidavit of service?
No, but not completed yet.
That is the problem, madam. Once in a week, the court is taking the matter and you have not done that to after 15 days. Last week, this court has not taken. Then?
We have solved, my lord, but it is not completed yet, right?
Not today. Yes, next.
Right.
Call the 11.
My lord, I beg to appear on behalf of the opposite party number 2. Well, my learned friend has served me a copy on the last
received
occasion. Your
copy?
lordship's direction, yes, madam.
Directors of the opposite
If
party
it was
to find.
satisfied, my lord, I couldn't start to the state, my lord.
Why not
And,
south? Why not south to the state?
And my lord, I couldn't start file the supplementary affidavit to you as because the petitioner is the petitioner made an accident before the.
My lord will
going
kindly
to
take
the
up this matter.
Kumbh
This
Mela.
matter has nothing, my lord, so far as my learned friend is trying to, my lord.
Nobody will come this court to argue the matter.
Yes, I know. I will tell your lordship what it is. My lord, this petitioner, my lord, an allegation was made against her for hate speech. And my lord, she has been doing since last 5 years. The criminal antecedents are there. And my lord, time and again, in spite of repeated directions, my lord, she has not obeyed. Now, my lord, so far as this complaint is concerned, may I place one document, my lord, where my learned friend's client had gone for before the coordinate division bench, my lord, seeking for anticipatory bail. So this report was filed by the state. Even if the state is not there, my lord will kindly comes to, my lord, page 9. Your lordship will just come. My lord, I'm sorry for the matter. There are certain lines which are marked. Page 9, my lord. Kindly see what's her interview, my lord. My lord, from the 4th line, Makka Liquor Shop.
Page 9?
Yes, page 9.
Yes.
Takes the first paragraph to interview of this petitioner in Shining India News portal. My lord, and then sees the last paragraph. Muhammad, I don't even want to. My lord, this is, my lord, she is trying to get a cheap publicity. That is all right. 19(1)(a) of the Constitution of India gives me the right and liberty to make freedom of speech. But at the same time, your lordship also see 19(2). My lord, completely, my lord, creating disharmony amongst the people of state of not only West Bengal, but throughout India. Entire India complaints are being lodged against this petition. And they have come for quashing. Now, my lord, my learned friend on the last occasion was saying that an anticipatory bail was granted. Kindly have a look at the observations. Bail was granted because she went and complied the 35(3) notice and she's removed those videos. But so far as offense is concerned, my lord kindly sees the observation. Paragraph 6. Paragraph 5. The petitioner's interviews contains grave insinuations against a religious community. We are conscious petitioner has freedom of speech. However, the freedom does not entitle her to incite hatred amongst communities. Contrarian views with regard to relations between different religious communities and concept of secularism, a cherished basic structure of the Indian Constitution, is understandable. In a pluralist democracy, it is not expected everyone would speak in the same tone or share similar sentiment. The socio-democratic fabric of the country is elastic enough to accommodate even unpopular views. However, the bandwidth of freedom of expression does not give a license to indulge in hate speech. Recently, your lordship is aware of a judgment.
We need to file some more documents. I'll file
What
the supplementary documents.
What document?
Some
See, this is a quashing proceeding.
Yes.
This is a quashing proceeding.
Yes,
You
sir.
file this application for quashing of the criminal proceeding. Correct?
Yes, my lord.
For the quashing proceeding, you cannot bring a new document from your own pocket.
But some several
Correct. The
complaints
court
has been
has
lodged against the petitioner.
maybe whatever it may be, it is the settled law. For the quashing of the proceeding, what the document relied by the police during the investigation, that is to be taken into consideration. If you want to you want that the other document is to be taken into consideration, you are free to deal with the said document during the evidence at the time of trial,
Yes.
not at the time of quashing of the FIR. The court cannot look into any third-party document. This is the settled law as per as on date.
And they have challenged the FIR. Lordship knows.
If you want to produce any document, then you have to go for the trial. And if you want the quashing, you serve the notice to the state. I will call for the report. Matter can be disposed of. Yes. Why you are not serving to the state? Why you are not serving to the
And that
state?
is the direction.
In spite of the direction,
Maybe in some reasons.
suffering for the petitioner, suffering for the opposite party number 1 or 2?
2, my lord.
Opposite party number 2.
There are
Counsel for the petitioner has filed affidavit of service showing the
2 and 3 both.
2
Sorry,
and 3.
2 and 3 both.
Counsel for the petitioner has filed affidavit of service showing the copy of the application is served upon the learned counsel for the opposite party number 2 and 3. Well, counsel for the petitioner press for time to serve the copy upon the state respondent. Full stop. Considering the submission made by the counsel for the petitioner, petition is directed to serve the copy of the application along with the document to the state respondent within a week from date, and let the matter appear on 30th of March.
For 2 weeks, my lord. Kindly adjourn is for 2 weeks.
For state, to state why 2 weeks? It is the government advice. Either you to give the APP or PP, whatever it may be, or additional PP.
Kindly,
Let the matter appear on 13th of March. It is made clear that if in the meantime the petitioner failed to serve the copy of application along with the document to the state respondent, the petition will be taken, the petition will be dismissed.
I'm grateful. But may I take back those 2 copy, or your lordship keeps it in the record?
No, take.
I'm grateful. I'm so grateful.
My lord, may I please mention item number 57?
Let first appellate side over. Any appellate side? Okay. Yes, God is grateful.
My lord, item number 57 on the non-commercial list of the register. I'm on notice, my lord, mentioning upon notice. My lord, the interim order had expired on the 12th of February. The advocate on record, my lord, while returning from the Kumbh Mela, my lord, he got delayed. He could not mention that day. Then later, my lord, when we mentioned, your lordship said now file an application because the interim order has expired. My lord, the man is 92 years old. He was very ill. He has had to, my lord, file an application now through a constituted attorney. That, my lord, took a few days. My lord, kindly, my lord, be pleased to please extend the interim order.
Which order? Where is which case?
Application is GA2, my lord.
Which case you are referring? It is listed.
Yeah, my lord, item number 57 today.
57?
But GA 57, my lord. GA2, my lord, is not listed, even though, my lord, the file is before your lordship's court today. We are told the file is there. We've complied with all formalities, my lord. But the listing hasn't happened of GA2.
Who's for the other side?
My lord, my friend has the only advocate.
The respondent, partly. The matter is what is granted for the order, interim order 14 Act 2025.
Yes.
But they did not communicate on that time. Order 39 rules is not communicated during that time.
So what you want, whether you are in objection, you are having objection.
No, then, my lord, on contest, my lord, kindly, your lordship has given a reasoned order, making a primacy finding.
But you have missed the bus, sir. Court has given the reasoned order for limited period. On the limited period, you fail to come before this court for extension. Every advocates are coming, taking extension of time. This court is granting. In every case, you are very lazy in the matters.
My lord, I am bound
Every
down.
cases.
My lord, I bow down to the fact, my lord, that certainly, my lord, we could not have gotten an oral extension because the time had expired. But we have, my lord, preferred an application.
Okay, preferred an application.
Explaining
It will be taken up for
GA
what he is objecting for that.
GA2, my lord.
Without hearing, I cannot. That let the matter come in the list. I will see.
Would your lordship list, my lord, then
It is
GA2?
there. When the matter will be taken, I will. Yes. Another.
Your lordship, extension of interim order. Your lordship, I'm mentioning upon notice. I'm extremely sorry, your lordship. I was not aware that the mentioning is taken up at 11:20 today. Lordship was pleased to extend it till 27th of February. It's expiring today.
Where is the order?
Lordship, there are 2 mentioning slips and 1 order. Common order was passed in 2 suits, your lordship.
2 suits?
Yes, your
Item
lordship.
number?
Your lordship, it's not there in the list. It's not there in the list.
Not
Your
the
lordship,
list.
though it was there was a direction for it to remain in the list.
So and so appearing for the plaintiff. The plaintiff has mentioned the matter after service of notice upon the defendant, but even after receipt of the notice, none appears on behalf of the defendant. Counsel for the plaintiff submits that the interim order granted earlier is going to be expired today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till the non-commercial.
Non-commercial, your lordship.
Till 2nd of April 2025 or until further order, whichever is earlier. दोनों एक साथ कर देना.
Grateful.